All right. Just go ahead and get us on the record. Before we get started, for the record, let me just say that the parties know this because we discussed this via email earlier this morning, but one of our jurors will not be back. He has been hospitalized. His wife phoned the court, actually phoned the jury administrator to say that he was hospitalized and wouldn't be able to be here today. I went ahead and excused him from further service since we have 3 alternates. So just getting that on the record. Is there anything else we need to take up? Here's what I'm thinking. We'll see how far we get in your proof today. At some point, let the jury go, talk about instructions, and see where we'll be tomorrow.
And Judge, I know they're not here, but I feel better approaching. If we could approach.
You want white noise?
Yeah, I guess.
Hold on. So we are going to actually go ahead and argue instructions. So I'm going to tell the jury what's going on. Okay, perfect. And then I'm not actually going to come back and get that one. All right, well, you all can go ahead and have a seat. We'll talk about instructions. So when we were here last week, I indicated to counsel for both sides that generally with instructions, what I will do is look to see where they're different and go through them that way. However, because I did not get instructions until this morning, I have not had time to do that. So, I'm just going to kind of go right into it. All right, let's look at the Commonwealth's instruction with regards to the defendant's instructions with regards to presumption of innocence. Is there any objection to that inclusion? It appears to me to be the standard Cooper's instruction for presumption of innocence. It's this. I'm looking at the defense's version of instructions, their first page of actual instructions.
I have it under instruction number 8. It's the same.
Oh, do you?
Yeah.
And so then does the defense have a position on whether it comes before or after the instructions as to the various counts of the indictment?
Judge, I don't know that the court is compelled to do it one way or the other.
It doesn't matter to me.
It's our preference that it go first.
Okay. And then the Commonwealth also included a definition for unanimous verdict. Do you want that included as well?
That's fine. I wasn't sure. I couldn't remember. I thought I did have that
Maybe you have it at the end.
near the end, right before
That's fine.
the-
We'll just continue going through yours. All right, definitions. Are you all aware of any differences in your kindred definitions?
Yes, there are a lot. The Commonwealth is only asking for an instruction on intentional murder. So that cuts out a lot of the definitions that we submitted. We submitted definitions on intentionally, complicity, and official proceeding.
For the defense,
Judge,
what is the basis for including wantonly or recklessly?
well, Judge, the indictment says wantonly in it on all 3 of the murder counts. So based on the actual charges themselves, we thought that it should be there. There wasn't any amendment, nor do I think that we would object at this point to an amendment of the indictment or of the charges.
I don't think recklessly is in there.
No, I was
Okay, but just
specifically
for
referring to
wantonly?
wanton.
Okay.
Judge, we are asking for lessers, and I don't know if the Commonwealth appears not to have proposed those, but it is our motion as part of our proposed instructions to ask for lesser includeds, which would include manslaughter in the first, manslaughter in the second, reckless, which are the standard lessers on any homicide, and then also based on the evidence that's been presented, as well as the deals that were offered to the co-defendants, we believe that facilitation should be an option for the jury.
All right, just a moment. So as to wantonly, I think based on the charge, wantonly should be included, but does someone have any objection to the wantonly definition being included?
We do, Judge, because there's been no evidence presented at trial that would support anything but intentional in this case. I realize their defense is that he is not the one who did it, but the evidence at trial is that these...
Can I tell you what my concern is? My concern is that without wantonly, the jury would not be able to find that even if the purpose wasn't to intend to kill, that it doesn't fit under intentional murder instead of wanton.
If the court is going to give a wanton murder, then we would request that it be a combination instruction, as is allowed under the law.
Can you tell me what you mean by that?
I'm sorry, an instruction that's on one page says...
Oh, yes, that's what I'm talking about.
or wantonly, and so
That's
two
what I
separate things.
was referring to as the indictment reigns.
Yes. And the courts have commonly found that throughout the years that is a proper instruction, and that it is proper for a jury to find, if they are considering intentional and wanton, that it could be under the facts of the case, that some could find intentional and some could find wanton, but it is still a unanimous verdict.
Judge, we respectfully disagree with the Commonwealth under the facts of this case. One of the issues, Judge, The Commonwealth's proposed instruction does not have that. We did propose a separate wanton murder instruction, but the significance there is that the penalty results would potentially be different. So for a jury to reach a conclusion and have us not know whether they found it to be intentional or wanton prevents us from knowing how to proceed in a possible penalty phase. And I can go into more detail about why that
I mean,
is.
it doesn't. It might change your strategy, but it certainly doesn't prevent you from being able to do that.
Judge, if in fact the jury found guilt under a wanton murder instruction, then it would no longer be an aggravated murder, and therefore 2 of the possible penalties would disappear. So that's a pretty significant difference.
Is that correct? I didn't think that that was true. If they found wanton murder, not manslaughter, not just wanton murder.
I believe, Judge, that under the aggravating statute, 532.025, and I'm going to pull it up. I
Thank you.
don't expect you to take my word for it.
No, I do understand that you know what you're doing.
That the aggravating factor requires multiple murders that are intentionally committed.
I see. 532.035 is repealed. Ms. Jones-Brown? Oh, you're looking too? Okay.
So, it's 532.025 2 for the specific one.
Oh, I see.
Number
Aggravating or
6.
mitigating circumstances.
Yes.
Well, to that, I would say, Judge, that the law does allow a combination instruction. I understand their point as to penalty. I would think that a way to cure this would be to ask in penalty, like to make that part of the penalty phase instructions if we get to that point, so that they
Yeah, we've
cannot
done that
impose
before.
the aggravator unless they have found that it was intentional.
It seems like it's inviting confusion, Judge, to give them an instruction that defines murder and the actions in one phase one way, and then defines it differently in the second phase.
Well, it's not defining it differently, it's just splitting up the definition.
Yes, if we're comfortable with that in the second phase, I don't see why we wouldn't be comfortable in the first.
To split up the instruction invites the possibility that you could have 6 jurors who believe this was an intentional murder, 6 who believe it was a wanton murder. They're not unanimous on either count 1 or count 2 under the proposed instructions. Therefore, they can't sign either of those jury forms, but all 12 believe that this was a murder. That's not the state of the law. The state of the law is that it is a unanimous verdict, even though some might think intentional and some might think wanton.
And we would respectfully disagree that that would be appropriate under the charges in this case, and specifically under the wording of the indictment, counts 1, 2, and 3. I can say, Judge, a lot of courts do give, the separate instructions just for the clarity, just so we all know.
And the Commonwealth objects to, intentional or wanton.
I mean, it is our
Separate
preference that
instructions.
this just goes forward unintentional. But I understand what the court's saying, so I'm not objecting to the wanton. I am just asking for it to be a combination instruction, and then on penalty, they would have to find beyond a reasonable doubt that these murders were intentional to get the 2 aggravated possibilities.
That is, in fact, how we did it last time, and there was just a case published that talked about that being appropriate.
I apologize.
We did that for like, are you finding it to be a violent offense?
I see the analogy, though I don't know that it necessarily is controlling in our case, Judge.
No, I understand. All right, I'm going to come back to, I'm going to do one or the other. I'm either going to do a separate instruction for one or combine it, and then so the jury to make a finding and sentencing as to intentional or one. Let me come back to that after we've talked about other lessers.
Yes, Judge.
All right, so what is the defense's position as to why a facilitation charge should be included?
Judge, I believe that the evidence itself has, the Commonwealth is asking for a complicity instruction, and if we look at the definition of complicity, which we included in our definitions, and the definition of facilitation, you can see how in any complicity case, facilitation is raised, and in particular in this case, there has been more than a little bit of evidence suggesting that Mr. Rhodes may have been present and may have participated, but may not in fact have been the one who caused the deaths. And that is classic facilitation. The Commonwealth has sort of forged a trail for us by the manner in which they've dealt with the two co-defendants, where they concluded that in fact their actions, even though they were involved and present, merited a facilitation result. It is our position that the facts as presented at a minimum allow the jury to potentially reach that result for Mr. Rhodes.
The Commonwealth objects, Judge. The way that the Commonwealth and various defense counsel choose to settle co-defendants does not then bind this court who sat on this trial and heard this evidence as to any certain theory. There has been no evidence in this case that the defendant was present but didn't do anything and just allowed it to happen. The evidence has been, this is sort of an all or nothing. He either was there directing all this and participating in this, or he wasn't. So facilitation is more of a disinterest in the outcome, which is distinct from complicity, in which somebody is engaged in and participating with a view towards the outcome that happens.
Judge, if the Commonwealth thought that the only issue on the table was an all or nothing, where Mr. Rhodes had actually committed the act, then complicity wouldn't be part of their instruction and part of their indictment.
I don't believe that there has been any evidence put forward other than a theory where this was Brice Rhodes' idea. So I don't think a facilitation instruction is appropriate. In that case, because of that, and because I just don't believe that from the evidence that's been presented, any juror could find that Mr. Rhodes' actions were facilitation. I think he's all in or nothing on that. I'm going to deny that instruction. First-degree manslaughter.
We believe that the evidence, that a reasonable juror could conclude that there was an intent to injure and seriously injure, as defined by the statutes, without an intent to kill, which is a classic manslaughter in the first result, Judge.
And can you tell me any particular evidence you point to in reliance on that?
Yes, Judge. And again, we're talking about the role specifically of Mr. Rhodes, the discharge under the evidence of what appears to be a single shot is not necessarily an intent to kill. I'm not in any way Rhodes was holding the gun or pulled the trigger, but I'm saying whoever. I don't think that that's sufficient to necessarily automatically amount only to murder charge. And as far as Maurice and Larry,
Okay. And as for second-degree manslaughter, same question.
well, Judge, we believe that the Commonwealth's indictment listed wanton murder, and the court has indicated the intent to go forward with instructing the jury on wanton murder. Manslaughter in the second degree is almost identical to a wanton murder and is contained within a wanton murder. The difference is what is the additional element of manifesting extreme indifference to human life. That is a nebulous concept that I think lies with the jury rather than us. And I believe that if a reasonable juror could find a wanton murder, that same reasonable juror could find manslaughter in the second degree.
Commonwealth, what is your position on both first degree and second degree?
Judge, I don't think that there's been any evidence in this case that would allow a first-degree murder. The evidence that has been presented is that the intent in going to 41st Street was to kill somebody with a price on his head. That he stated, the evidence is that he stated that intent to the witnesses as they testified. He shot a man. They've already got the wanton instruction, which I think covers whether it was an intentional or just something that we in the court, under these definitions, consider wanton. There's just no evidence that he intended to shoot but not kill him. As for the second degree, I think that once you give a wanton murder, you have to give a man too. So I'm not contesting that one if there's a wanton given.
Okay. That makes sense here.
I might be wrong about that, but I feel like there was a case a couple years ago.
I feel like the instruction's wonky, though.
Unintentionally so, Judge.
I know.
Just wanting
I'm sure.
Yeah, I think so. And I have a copy of Cooper's that is
I've got it.
there's another instruction in there that says and wasn't. It has the optional and wasn't in self-defense and stuff like that, but that doesn't apply in our case.
Actually, Judge, in Parker versus Commonwealth in 2007, so this wasn't even recent. With the wanton murder instruction should come instructions on lesser included offenses, notably here an instruction on second-degree manslaughter.
Does somebody have their phone playing something? I keep hearing some, like, video playing or something. Okay. Yeah. I was just looking at the wrong one. Okay. So I think that this second degree one, the way it's written, is fine. So shooting him with a firearm And accidentally, it does match up perfectly with Cooper's. I was just looking at the wrong thing. Sorry about that. Okay, in reading the second-degree manslaughter instruction, well, let me also hear any arguments regarding the reckless homicide and what evidence you believe supports a reckless homicide instruction.
I'll be honest, Judge, I didn't read any case law that required it. I'm used to it being given when a man two has been given. Usually they sort of go hand in hand. They have a lot in common as far as the mens rea and issues like that. So we proposed it, but I'm not aware of a case that requires it. We think it would still be appropriate along with the same argument basically as the manslaughter in the second degree.
Unless the Commonwealth wants it included, I'm not included to allow it. Okay, I'm going to deny that. I don't think the evidence supports that. And then that also means that I'm looking at removing recklessly from the definition.
If you're looking at the definitions for the defense, Judge, I think you had excluded manslaughter first, which means EED shouldn't be in there.
I did not include manslaughter first.
No, exclude.
Oh,
Exclude.
yes. Okay, thank you.
So I was just saying, there are other definitions we can take out.
Facilitation can come out. Well, I guess I'll come back to that because we haven't gotten to the other instructions. I think that's it for now. Okay. All right, let me not get these all out of order. I really wish these were page numbered.
I'm sorry.
It's okay. I just might.
But if the page number, Judge,
Lose
we
track.
take one out, then we're all confused because the page number.
There we go. All right. Now, here's where I need the defense to tell me what comes after the reckless homicide instruction as to Christopher Jones. Is it more, is it like another presumption of innocence, or does it go straight to intentional murder?
I think you go straight to the next count, Judge. Count
Okay.
two.
And that is the intentional murder as regards to Maurice Gordon.
Yes, Judge, I believe so.
Ms. Jones-Browning, objection to how that's written. On the reckless homicide, since I'm not allowing it, I think that because there's going to be the second-degree manslaughter charge, to me it makes more sense to have one instruction for intentional, one instruction for wanton, one instruction for man two. So that during closings, you're able to explain to the jury what the differences are.
I agree with the court.
Rather than trying to explain those differences later. If it was, if we weren't also having the second degree manslaughter put in there, I think I would think a little differently about it, like decide later. But I think as long as they're going to have to decide for one act, and then act two, and then act three, for as long as they're going to have to decide each one already, why not just have them go ahead and decide it based on a separate instruction for each one.
And this might not be the case where it really matters, but theoretically in a case where a jury is having trouble deciding intentional or wanton, how does that scenario account for the fact that they are allowed to convict on murder even if they disagree on the theory?
Mm-hmm. Yeah. Yeah, that's a good point. Y'all want to add anything on that for the defense?
Judge, I think that's raising an issue that is an unlikely event. I think the more
Famous last words.
yes,
Mr.
Judge, it
Griffiths.
is I think the more likely result is we understand these. Hopefully, we understand them pretty well, right? I think that they're confusing to the average person, and setting them out with separate instructions is just a lot clearer to the jurors and makes a lot more sense to the jurors.
It might, and I understand that, but I agree with the Commonwealth. I think it's too great of a chance of them not understanding and not knowing. You know, if some of them think it's wanton and some of them think it's intentional, we'll be in a rough spot.
Would that be, could that be resolved by an additional instruction or an admonition?
It could, but I don't really see the point of that. But I guess the question for me really is, should we have a separate instruction after that, like if you have found the defendant guilty under instruction number blah, 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 do you unanimously agree it was intentional? And go ahead and knock it out prior to sentencing.
I think that would, I think that would work, Judge. I think that would
Okay.
fix it.
All right.
So
And I'll
that-
go back and look at that other one we did for how we put that in there, and I'll let you all know what it is.
Okay. And would that then go sort of near the end, one of the last ones?
It'll be like the intentional or wanton instruction, and then the next one, if you found guilt under the last instruction, and then the language of do you believe it was wanton or intentional, and then very next thing, if you did not find the defendant guilty under instructions 1 or 2, you may find him guilty under instruction 3 if and only if for the second-degree manslaughter.
Are these going to be numbered like 1A, 1B for murder
Yeah.
and Mansu
Yeah.
for Christopher Jones?
Yeah,
and then
I'll
2A,
rewrite 'em
2B,
all.
3A, 3B?
Yeah. And so, go ahead.
Oh, I was just going to say, we tried to do that, like the ones I have at the back, Judge, are by count, and that may satisfy what the Commonwealth is talking about.
That's how I'll do them. I'll do them by count.
Yeah, 'cause I think if you do A and B, it helps the jury not find him guilty of both. Not.
All right, let's move on as to the count with regards to Maurice Gordon. Are anybody's arguments any different? If not, I'm just going to rule the same on each one.
No different.
The only difference, the facts are different, obviously, Judge. I think Maurice Gordon and Larry Ordway, those two are pretty much identical as far as the arguments go. There is additional evidence regarding actions of multiple people rather than a claim of actions of a single person,
Okay.
which I think would justify the facilitation instruction on count 2 and count 3.
I understand. Ms. Jones-Brown?
I don't have any additional arguments to what I've already made. And we would continue to object to facilitation.
So, from my perspective, the testimony, there was not anyone whose testimony supported an idea that that Mr. Rhodes was facilitating someone else in committing those crimes. Can you point me to what you would rely on?
Specifically, Judge, just the testimony that literally said things like everyone stabbed, rather than just.
Well, the testimony I heard was like, Brice made me also stab. Was there a witness who testified to something other than, being told to stab the person after they had already been stabbed?
Even the witnesses who testified that two other people that weren't here, that we never saw, one who was identified, one who was not identified, also were involved and also were stabbing. And both of the witnesses called with the Commonwealth said that two other people stabbed both of the victims in count 2 and 3. So we believe that would also support a possible verdict of facilitation rather than.
Okay. I do not believe that any evidence that was produced would allow the jury to find Mr. Rhodes guilty of facilitation to murder or first-degree manslaughter for the same reasons, that there was not any testimony other than testimony that it was his idea, that he was directing the actions of others. Do we need to make additional record with regards to Larry Ordway, or is it the same argument?
Same argument.
Okay, same ruling. And then we get to tampering. Are your all's tampering instructions the same?
They're largely the same. They just have evidence. I listed some items of evidence.
I don't. That's fine, Judge. I don't.
I'm relying on the case. Hackett versus Commonwealth.
That's fine. That's,
Yeah.
I'll use yours as it is.
I do want to change, have an amendment to mine. I would like it to say and or instead of and. I believe that the jury could find any one item was tampered with and it would support this.
Oh, you mean on the final line of A?
Yeah, so it would say
Yeah, I gotcha.
and
or the
blanket
back seat of
or-
the blue mouse, I'll allow that. Okay. And then abuse of a corpse. Looks like they are largely the same, although the Commonwealth is a little more like fact, just barely a little more fact specific.
We don't object, Judge, to the Commonwealth filing.
Okay, we'll do that for each of them. Okay, so now we get to the other instructions. Let me briefly go back to definitions. So the Commonwealth's definitions are just intentionally, complicity, and official proceeding for the defense. Intentionally, wantonly, physical force, deadly physical force, serious physical injury, and complicity.
I think we can get rid of the serious physical injury due to, that was for manslaughter in the first degree.
That's correct, Judge.
And so I think I could then just add in official proceeding. So the definitions would be for intentionally, wantonly, physical force, deadly physical force, complicity, and official proceeding.
I think that's right. I didn't put in official proceeding. That's my fault.
What is the physical force and deadly physical force from? Where is that?
Deadly physical force. You know, I think that might be from,
That might be a man one.
that's what I was thinking.
I believe that's why I put it in there.
No.
I think it's from extreme emotional disturbance. So removing that due to removing man one.
It is. It is.
The need for that.
Okay. So then add in official proceeding. Okay. All right, and then at the end of each individual instruction, the Commonwealth has presumption of innocence, which we're putting at the front. We won't need it there. Both of you have unanimous verdict. Let's see. Okay. So let's talk about this right to remain silent instruction. Any objection to that?
I have it at the end of presumption of innocence, but I don't object to it being separated out.
I gotcha. Then right to remain silent. All right. Let's go ahead and talk about the spoliation potential instruction. The defense is requesting a tainted evidence instruction.
Yes, Judge. We believe that primarily applies to the car seat, lack thereof. There was a lot of testimony. There was admission by the police in this case that that they did say under oath on 2 occasions, as well as 4 years later, 3 years later, excuse me, in this courtroom, that there was a car seat, and it was included in the police report. And now, of course, the court is well aware we have not seen one, and they're saying that there isn't one. There's different versions of this instruction, Judge. This is the one that I put in. We wanted to change the language to missing. Obviously, that's fine with me too, but this is the one I thought best matched the facts in the case. It's frankly less confrontational in some sense. But so I chose a version and form that I thought would work better with the facts that we heard and the evidence in this case.
Ms. Jones-Brown.
Judge, the Commonwealth does object to this. The evidence, while it does show, I mean, the court's very well aware of what was testified to, and I think an inference or an argument on their part can be made to the record keeping of the police department or the procedures of the police department, or even if they want to shoot for the credibility of the lead detective, but there is no evidence that the backseat was recovered and then lost. So we would object to this.
here's part of the problem. Part of the problem here is that I don't feel it was ever established whether a back seat ever existed. That's the problem I'm having, is that it is not as though we know, A, there definitely was this piece of evidence, and B, then it was lost. In fact, I think it's statutorily they're not, if it did exist, it potentially could be a violation of the law if it was destroyed or not kept, if it contained bodily fluid. KRS 524-140 talks about how if an item is found that contains biological markers such as bodily fluids, it is a violation of the law to dispose of it. The problem is I don't really feel like it was ever established that it did in fact exist.
I think the question to me, it revolves around, the reason I submitted the instruction is I believe that the court and the jury are able to rely upon sworn testimony. And the officer in the case, Detective Tonelli, testified under oath at the preliminary hearing, and he testified that there was one. He testified under oath at the grand jury that there was one. And then in this courtroom, 3 years later, told Judge Cunningham that the biggest piece of evidence that they had to bring was the car seat. And actually, he may not have been under oath that third time, Judge.
And it doesn't matter. Here's the issue that I'm having, and I'm leaning towards allowing the instruction, but the issue that I'm having is that I just don't really feel like it was ever firmed up. You know, Tonelli's testimony was basically, yes, I said that, I was wrong. But I don't know. I really wish this had been a pretrial hearing, to be honest. But I don't feel like there was ever any testimony that it did, in fact, exist. Like, to me, Tonelli's testimony was more like, I thought we had the physical back seat, but we never did. But I don't feel like it was very clear, and frankly, I don't really think that the defendant should be penalized when it wasn't clear. And in fact, there are at least 3 instances of Tonelli saying that there is a back seat.
Well, Judge, at the PC hearing, he said, we believe the seat was located. We are waiting for our forensics analysis to make sure and confirm that. He qualified it. And that is what he believed up until he got the CSU report.
Which said?
Well, which listed the items taken from the dumpster and did not include a back seat.
And when was that?
Not until that fall.
Post grand jury presentation?
Post-grand jury. Now, 3 years later, yes,
yeah,
we were just sitting here and we were throwing out ideas. I mean, it was just like this.
I know. But, you know, if you're the defendant and this detective is twice saying that there is a back seat, even though it's not listed in discovery, and then 3 years later he mentions bringing it into court, I think it was reasonable for them to rely on thinking there was a back seat, too.
But then that was cured a week later when we came to court. And this was subject to extensive litigation under Judge Cunningham.
Oh, it was?
Yes.
Was there a missing evidence instruction argument?
No, but I was accused of prosecutorial misconduct. I had to respond to a motion about this. It went on for quite a while.
The biggest problem I have is that I still don't really have any conclusive testimony about whether it ever did exist. You know, we had all these CSU people in here. Why not just have someone definitively say, no, we never had a back seat?
Judge, I feel like that was conclusively testified to because the defense asked it of almost every witness that testified. And it was not found in the dumpster. Now, I thought what the court was saying was, we don't know if it was ever in his car. And that is something that we don't, like, maybe it was taken out 3 years earlier. Maybe he bought the car with no back seat.
Right.
But every police witness who testified, when asked, said that they recovered no back seats. and the person who would have what Detective Tonelli was testifying about at the PC hearing and the grand jury was the dumpster search, and Detective Peters and Rebecca Kimmer from CSU testified that no backseat was recovered in the dumpster, although they initially thought something might be a backseat.
What evidence rule is missing evidence covered by?
There's a Cooper's heading somewhere in there, Judge, about it. I understand the court's looking it up. Judge, just to respond, for what it's worth, I think this ambiguity is why it ended up as a jury.
I mean, that's kind of what I'm leaning towards is like, the problem is it's been left pretty unclear, and I think that should lean towards the defendant. Let me look at this, 2.06. But there was not ever a spoliation or missing evidence instruction before now, right?
No.
Okay.
No, we had no argument on that point.
I'm going to allow the instruction. I do think that based on the evidence as it came out, and I'm looking at the case law in Beglin and coincidentally a case called Ordway, the Commonwealth. So it says the court held there is no special or unique threshold of proof involved, so long as the trial court is satisfied that a reasonable juror could believe from the evidence the substance of the first clause, the instruction is in order. And I do believe that the way that the proof came out, a reasonable juror could believe that the backseat existed at some point. So I'm going to allow that instruction. All right. And then we have the unanimous verdict instruction. They are substantially similar. In fact, I think that the Commonwealth is just a little bit longer, but they're pretty much the same. Does anybody have any position on whether it should say the verdict of the jury must be in writing, must be unanimous, and must be signed by one of these foremen, or actually foreperson, or the verdict of the jury must be unanimous in finding the defendant guilty or not guilty and must be signed by one of you as foreperson. You may use the form provided at the end of instructions. Anybody have a position on that?
No, Judge. I mean, I'm not looking at Cooper's on it. I think whatever the...
Okay.
Pretty close.
All right. Then we have our verdict forms. So these will be, as we discussed, for the first 3 counts of the indictment will be A, B, or C. And then the others will just be guilty or not guilty. So our jury, oh gosh, they're already back. Let me get these written up so you all can have about 5 minutes to review them, okay?
Yes, and Judge, we found some typos. Do you need us to communicate those, or do you already have those?
I don't think I already have them, but when I put this all together, we'll see if they're still there or not.
Okay.
Thanks. All right, you all can, this is going to take me about 10 minutes, so we'll take a 10-minute break. John, would you mind to let the jurors know it's going to be about another 10 minutes? Thanks. Okay. What do we got?
We noticed a couple typos on page 2. We thought that physical force and extreme emotional disturbance were being taken out.
Okay. Physical force?
Yes. And EED. None of the murder or manslaughter, well, no.
Hang on one second.
Oh, sorry.
Okay.
The murder charges do not have complicity, although the manslaughter charges do.
So, we're doing intentionally, wantonly, complicity, and official proceeding, right?
Yes.
Okay. Got it.
So then, Judge, on page, for instance, 4, on the murder 1A, it does not have complicity in it.
Okay.
So that needs to be added. It is in 1B, and then that pattern follows for each of the murder charges. Complicity needs to be added to each of them.
Okay, so on 1B, 2B, and 3B?
1A, 2A, and 3A. It's in all of the manslaughter charges, but not in the murder charges.
Murder should be 1A, 2A, and 3A.
I'm sorry. The complicity language is not in the murder charges.
And it should be?
Yes.
And it
It's
should not, and it should also be in manslaughter?
correct.
Okay. And that should be in 1A, 2A, and 3AA.
Yes, ma'am.
Hang on, let me get that in.
I think it's
Okay.
So is it in, like, for instance, he acting alone or in complicity with others killed Christopher Jones by shooting him with a firearm?
No, it is, he killed Christopher Jones by himself or in complicity with others by shooting him with or by stabbing. Okay.
No objection. I noticed in 1B, it says he killed Christopher Jones by himself or in complicity with others, and then it should say by shooting him with a firearm.
Yes, I changed all of those.
Okay. And then, so for 2A murder and 3A murder, the same change with the complicity.
Yes, I've changed all of them.
The only other thing I noticed was that in the verdict forms, A, it says, we the jury find the defendant not guilty or murder instead of murder.
Okay.
That's all noticed by the Commonwealth.
We had a few other things we spotted, Judge.
Let me change that order of and the other ones as well. Okay.
Your Honor, on page 1, under unanimous verdict, I believe the court was going to change foreman to foreperson.
Yes, thank you.
And I'm not sure if that's the only location of that word, but I can
I'll
try.
double check it.
Yes, thank you. And then I believe the only other correction is a lettering on page 6. For example, on 2A, we have 2 Bs. I think it's the Word document is just trying to.
Does that make sense, Judge? It says B for the, instead of A for the first option, it says B, and then it says B again.
Oh, I see it.
And then on page 8 for instruction 3A,
Hang on just one second. Let me get that formatting correct. Okay.
on page 8 under 3A, on instruction 3A, we have a C and a B, which should be changed to an A and a B.
Got it.
And then I believe page 12, instruction number 6, we have element A, B, and D. The last one should be a C.
Page 12, you said?
Page 12, yes.
No, that goes under B.
Okay.
That's the, because it's not a separate element. That's just the intentional portion. So it should be the same for 2A and 3A.
Yeah, we already got it.
And then I believe the same lettering on page 15, 16, 17, and 18.
A instead of,
Be in our own list.
I see. Because it went to CD. I gotcha. Okay. Anything else?
Judge, we did do what you asked, and we discussed sort of the logic of today versus tomorrow. And I think that we concluded that it will not slow us down to do closings first thing tomorrow, as long as both sides are ready to go straight into penalty if that's necessary. And we can. We've already done penalty
I
instructions.
just hate to send them home, having been sitting here since 12:30. So we have to do instructions, and then you all think you'll be about an hour each.
I don't have no comment.
Is that right?
Yeah, probably less.
I think I'm just gonna push through. We're gonna make copies. Janelle has left, so it's me making the copies. Please bear with me.
You'd have to be like, hey, has everybody seen this? Okay.
He wrote a check out, because we're all like trying to give him money. He's like, no. I pay no. Hey, Danny paid like it's $300.
The copies are still running. While they are, I think I'm going to bring the jury in, check with them to see if there's any issues with the admonition, tell them what's going on with Tonelli being gone, let you all rest, approach, we'll do DV arguments again, but then the copies should be done. You ready? I'm nothing if not a multitasker. We talked about it already.
I knew this was a different one.
Well, thank you. All right, good afternoon. Let me apologize. You know, we try so hard to make things go as scheduled, and sometimes it just doesn't happen. I can't tell you how much I hate it when you all are sitting there for that long. But I assure you we were doing the best that we could. Is there anything that anybody needs to report with regards to the admonition? Did everybody get their phones over here? Okay. We have one juror missing, as you can see. What we understand is he's fine. I don't want you all to be worried about him, but we have gone ahead and excused him for health reasons. Also, Detective Tonelli, you'll see, is not here. With his permission, he has asked that I convey to you that he had to go out of state. His mother was having surgery, and we told him, you know, go ahead and go. We are going to move into the next phase of the trial. When we left Friday, the state had rested their case. Would the defense like to call any witnesses?
Your Honor, the defense rests.
All right. Would you all approach, please? Get the rest passed out to the jury in just a moment. You can have a seat.
Thank you, Your Honor.
You need something else? Well, don't forget to hit clear or it'll print 20 next time. Deputy Mills, there should be 14 copies of instructions. Now, ladies and gentlemen, I am going to instruct you on the law of the case. That's what you're getting a copy of, is your instructions as jurors. After I have instructed you, and that is a thing that I must do, is read through these all the way for all of you. After I have read the instructions, the attorneys will give closing arguments. Closing arguments, just like I told you in opening statements, are not evidence, but they are the lawyer's chance to talk to you about how they sum up the evidence and recommend how you should find after closing arguments. Now, after closings, you will retire to the jury room, where the first thing you're going to do is select a foreperson. That person will preside over your deliberations. It doesn't matter really who it is, as long as you all agree that that person will be the foreperson. The foreperson's copy of your instructions, it really doesn't matter, but you need to have like one official copy. So generally the foreperson's copy will be the copy that you sign. There's no reason for the foreperson to sign any more than one copy, and that will be the copy that you return to the court. If you go back for deliberations and you have a question, please write it out and then knock on the door. There will be a deputy stationed outside the door of the deliberation room at all times. So if you have a question, you are allowed to ask questions. You would write it out, knock on the door or open the door, let the deputy know you have a question, and hand the deputy the paper, and then we will discuss it in here, and I may or may not answer your question. The same thing for when you reach a verdict. Just let the sheriff stationed outside your door know that you have reached a verdict, and we will bring you back in as soon as possible. Now, during deliberations, you can only talk to each other. The deputy will keep your phones. I'll give you a break before that if you need to call anybody and let them know that you might be here a while. If during your deliberations you need to use your phone or you have some kind of an emergency, please advise the sheriff. They, as I said, will be posted outside the door at all times. They will come and tell me and see if it is okay for you to use your phone. There are restrooms also in the area where the deliberation room is, so you don't need to leave for that purpose. All right, at this point, I'm going to read the instructions to the jury. In the case of 16 CR 1891, Commonwealth versus Brice Rhodes, these are the jury instructions. Presumption of innocence. The law presumes a defendant to be innocent of a crime, and the indictment shall not be considered as evidence or as having any weight against him. You shall find the defendant, Brice Rhodes, not guilty, unless you are satisfied from the evidence alone and beyond a reasonable doubt that he is guilty. If upon the whole case you have a reasonable doubt that he is guilty, you shall find him not guilty. Unanimous verdict. The verdict of the jury must be in writing, must be unanimous, and must be signed by one of you as foreperson. You should use the form provided at the end of these instructions in writing your verdict. Right to remain silent. A defendant is not compelled to testify, and the fact that the defendant, Brice Rhodes, did not testify in this case cannot be used as an inference of guilt and should not prejudice him in any way. Tainted evidence. If you believe from the evidence that there existed certain items that were potential evidence and that the agents or employees of the Commonwealth unintentionally tampered with them, you may but are not required to weigh this evidence in favor of the defense. Definitions. Intentionally. A person acts intentionally with respect to a result or to conduct when his conscious objective is to cause that result or engage in that conduct. Wantonly. A person acts wantonly with respect to a result or to a circumstance when he is aware and consciously disregards a substantial and unjustifiable risk that the result will occur or that the circumstance exists. The risk must be of such nature and degree that disregard thereof constitutes a gross deviation from the standard of care that a reasonable person would observe in the same situation. Complicity means that a person is guilty of an offense committed by another person when, with the intention of promoting or facilitating the commission of the offense, he solicits, commands, or engages in a conspiracy with such other person to commit the offense, or aids, counsels, or attempts to aid such person in planning or committing the act. Official proceeding means a proceeding heard before any legislative, judicial, administrative, or other governmental agency or official authorized to hear evidence under oath. Instruction number 1A, murder as to Christopher Jones. You shall find the defendant, Brice Rhodes, guilty under this instruction if and only if you believe from the evidence beyond a reasonable doubt all of the following. A, that in this county on or about May 4th, 2016, and before the finding of the indictment herein, he killed Christopher Jones by himself or in complicity with others by shooting him with a firearm. And B, that in so doing he caused the death of Christopher Jones intentionally, or that in so doing he was wantonly engaging in conduct which created a grave risk of death to another and thereby caused the death of Christopher Jones under circumstances manifesting an extreme indifference to human life. Please indicate your verdict using verdict form number 1A. The verdict forms correspond with the instruction numbers. If you find Mr. Rhodes not guilty under this instruction, proceed to instruction number 1B. If you find Mr. Rhodes guilty under this instruction, the verdict form will also require you to make a determination as to whether or not you unanimously believe Mr. Rhodes acted intentionally or he acted wantonly, as those terms are defined herein. Please only answer yes if you all unanimously agree that his actions were intentional, as that word has been defined. There will be a further proceeding at which you will fix his punishment. Next, proceed to instruction 2A. Instruction 1B, second-degree manslaughter as to Christopher Jones. If you do not find the defendant, Brice Rhodes, guilty under instruction number 1A, you will find the defendant guilty of second-degree manslaughter under this instruction if and only if you believe from the evidence beyond a reasonable doubt all of the following. A, that in this county on or about May 4th, 2016, and before the finding of the indictment herein, he killed Christopher Jones by himself or in complicity with others by shooting him with a firearm. and B, that in so doing he was acting wantonly, as that term is described in the definitions herein. Please indicate your verdict using verdict form 1B, then move on to instruction 2A. Instruction 2A, murder as to Maurice Gordon. You shall find the defendant Brice Rhodes guilty under this instruction if and only if you believe from the evidence beyond a reasonable doubt all of the following. A, that in this county on or about May 22nd, 2016, and before the finding of the indictment herein, he killed Maurice Gordon by himself or in complicity with others by stabbing him with a knife, and B, that in so doing he caused the death of Maurice Gordon intentionally, or that in so doing he was wantonly engaging in conduct which created a grave risk of death to another, and thereby caused the death of Maurice Gordon under circumstances manifesting an extreme indifference to human life. Please indicate your verdict using verdict form 2A. If you find Mr. Rhodes not guilty under this instruction, proceed to instruction 2B. If you find Mr. Rhodes guilty under this instruction, the verdict form will also require you to make a determination as to whether or not you unanimously believe Mr. Rhodes acted intentionally or he acted wantonly, as those terms are defined herein. Please only answer yes if you all unanimously agree that his actions were intentional, as that word has been defined. There will be a further proceeding at which you will fix his punishment. Next, proceed to instruction 3A. Instruction 2B, second-degree manslaughter as to Maurice Gordon. If you do not find the defendant Brice Rhodes guilty under either instruction number 2A, you will find the defendant guilty of second-degree manslaughter under this instruction if and only if you believe from the evidence beyond a reasonable doubt all of the following. A, that in this county on or about May 22nd, 2016, and before the finding of the indictment herein, he killed Maurice Gordon by himself or in complicity with others by stabbing him with a knife, and B, that in so doing he was acting wantonly, as that term is described in the definitions herein. Please indicate your verdict using form 2B, then move on to instruction 3A. Instruction number 3A, murder as to Larry Ordway. You shall find the defendant Brice Rhodes guilty under this instruction if and only if you believe from the evidence beyond a reasonable doubt all of the following. A, that in this county on or about May 22nd, 2016, and before the finding of the indictment herein, he killed Larry Ordway by himself or in complicity with others by stabbing him with a knife, and B, that in so doing he caused the death of Larry Ordway intentionally, or that in so doing he was wantonly engaging in conduct which created a grave risk of death to another, and thereby caused the death of Larry Ordway under circumstances manifesting an extreme indifference to human life. Please indicate your verdict using verdict form 3A. If you find Mr. Rhodes not guilty under this instruction, proceed to instruction 3B. If you find Mr. Rhodes guilty under this instruction, the verdict form will also require you to make a determination as to whether or not you unanimously believe Mr. Rhodes acted intentionally or he acted wantonly, as those terms are defined herein. Please only answer yes if you all unanimously agree that his actions were intentional, as that word has been defined. There will be a further proceeding at which you will fix his punishment. Next, proceed to instruction 4. Instruction 3B, second-degree manslaughter as to Larry Ordway. If you do not find the defendant Brice Rhodes guilty under instruction 2A, that should be 3A, you will find the defendant guilty of second-degree manslaughter under this instruction if and only if you believe from the evidence beyond a reasonable doubt all of the following. A, that in this county on or about May 22nd, 2016, and before the finding of the indictment herein, he killed Larry Ordway by himself or in complicity with others by stabbing him with a knife, and B, that in so doing he was acting wantonly, as that term is described in the definitions herein. Please indicate your verdict using form 3B, then move on to instruction 4. Instruction 4, tampering with physical evidence. You will find the defendant Brice Rhodes guilty of tampering with physical evidence under this instruction if, and only if, you believe from the evidence beyond a reasonable doubt all of the following. that in Jefferson County, on or about the 22nd day of May 2016, he, acting alone or in complicity with another or others, destroyed, mutilated, concealed, removed, or altered items from 763 North Height, including a pink blanket, the knife, and or the backseat of the blue Mazda, and that in so doing he believes that an official proceeding may be pending or instituted against him, and he did so with the intent to impair the availability of the evidence at such a proceeding. Please indicate your verdict using Form 4, then move on to Instruction 5. Instruction 5, abuse of a corpse, Maurice Gordon. You will find the defendant Brice Rhodes guilty of abuse of a corpse under this instruction if and only if you believe from the evidence beyond a reasonable doubt all of the following: that in Jefferson County, on or about the 22nd day of May 2016, he, acting alone or in complicity with another or others, placed the body of Maurice Gordon in a yard off an alley and attempted to burn it, and that he had no legal authority to do so, and that in so doing, he intentionally treated Maurice Gordon's body in a way that would outrage ordinary family sensibilities. Please indicate your verdict using Verdict Form 5, then move on to Instruction 6. Instruction 6, abuse of a corpse, Larry Ordway. You will find the defendant Brice Rhodes guilty of abuse of a corpse under this instruction if and only if you believe from the evidence beyond a reasonable doubt all of the following. You'll see there's a typo where the word following is written twice on this one and the one before. That in Jefferson County, on or about the 22nd day of May 2016, he, acting alone or in complicity with another or others, placed the body of Larry Ordway in a yard off an alley and attempted to burn it, and that he had no legal authority to do so, and that in doing so, he intentionally treated Larry Ordway's body in a way that would outrage ordinary family sensibilities. Please indicate your verdict using Form 6. This is followed then, ladies and gentlemen, by a single verdict form for each instruction that I have just read to you. You will need to follow those instructions, and as I said, have the foreperson sign as appropriate in line with your verdicts. Now, we are going to have closing arguments. I expect that they will last until about 5:15 or so, maybe 5:30. Would anyone like to take 5 minutes to step outside and make any calls or anything that you might need to make? Because once we're done with that, you'll go straight into deliberations.
Will we be here for late tonight?
That's up to you all. It just depends, on how it goes. So, does anybody need to step out? All right, let's take 5 minutes. I'll have you come back at 3:35. Please remember the admonition's still in place. Am I okay? No. But I'm going to keep going until I am. Just overwhelmed.
inevitably the sun came out. When the sun came out, that fort that appeared to be so strong, it looked like it would never collapse, never fall down. Every single time it did. Every time. The Commonwealth, in this case, bears a heavy burden. They admitted it in their opening. They bear the burden to prove to you every element beyond a reasonable doubt. And at times, they have seemed to have built the strongest, toughest fort that was going to last forever. I want to suggest to you that when you look at it and really think about it, it isn't so. Your job, and we talked a little bit about this when we were selecting the jury, it's not just one thing, it's multiple things. The most important thing that you do is you try to make sense from this witness stand of what really happened. You take the pieces of evidence that you have and you evaluate them. Decide which parts have credibility, which parts don't. When you're thinking about their case and you're thinking about what they proved beyond a reasonable doubt, that's what you have to go from. The evidence that you actually heard from the witness stand. Because the other part of your job, and there's a reason there's 12 of you, right? Because you caught something and maybe you missed something. You caught something else, maybe you missed something else. And that's why you get to talk, right? You're not going to do separate analysis. You sit in a room together and you have your notes. Some of you took a lot of notes, some of you took a little notes. That's up to you, right? That's your business. But you get to talk to each other, and you'll have the instructions from the court. And the instructions from the court are very important. That's why not only does the judge read them out loud, but each of you gets a copy. Those represent the actual law, the law that matters in this case. And then you get to do something that's sort of amazing, really. You get to apply the facts of this case to the law. That's part 2 of your job. You get to say, okay, now we've decided what happened. We've done the best we can to figure it out, right? And now we look and we say, did the prosecutor, did they meet their burden? Did they prove beyond a reasonable doubt? And then if they did, what did they prove? Because as the court read to you, there are multiple possible options. And then you're the ones who choose. Now, I'm going to talk to you for a little while, tell you what I saw, what I observed, what I think. The prosecutor's going to get up and do this exact same thing. Okay? What I say is not evidence. What the prosecutor says is not evidence. What you heard in the witness stand, that's the evidence. So let's talk about credibility for a second. You really heard 2 types of evidence in this case. You heard a lot of evidence from either police or people who work with the police. And then you also heard evidence from the other suspects. I'm going to talk about those separately. Because I want to be clear. I want to try and be as clear as I possibly can. There were a lot of witnesses who either were police or worked with the police. And they told you little pieces, really. No, there's a little piece, sort of like a puzzle. Little piece here, little piece there. Sometimes they fit, sometimes they don't. The prosecutor's going to tell you that they all fit. It all makes sense. It's clear, crystal clear. It's not. And you know them. You sat in this room. You heard the evidence from that witness stand. In their opening, prosecutor talked about, I want to get this right because I wrote it down, a monstrous bloody scene. I think those are the exact words the prosecutor used. Monstrous bloody scene. But we heard from the witness stand that was not true. What we heard from the witness stand is that there was an entire bunch of officers with a search warrant who can look at whatever they want that's on that search warrant, right? And went in the scene in Hyde Avenue, right, where we heard a lot of evidence. And they walked through and they didn't see much of anything. They walked through and they left. They took off and were gone for, though there was a little quibbling about it, it was about an hour and 45 minutes, something like that, before they decided they were coming back for the new search warrant, right? This was no monstrous bloody scene, blood everywhere, any of that sort of stuff. And we know that from the actual testimony we heard in the witness stand. But that's not what the prosecutors want you to think. They want you to picture it differently. I'm going to ask you to remember. Remember what the real evidence was from this real witness stand. We heard that the police weren't even able to videotape the scene. It sure would have been helpful for all of you. It would have been helpful to me. If there had been a videotape showing us what it really looked like that first time they went in, or the second time they went in. They said they had new evidence. They're going back 2 hours later, approximately. And on the third day of trial, we get handed a videotape. The missing videotape, which is completely, utterly black. Doesn't show that. That's not helpful. That doesn't help you. Doesn't help me. Doesn't help anyone understand anything. All right? It's important to remember what you actually saw, what we actually learned from the witness stand. You know, there was, right here, these photos that I tried so hard to find the other day. Found them in advance. You know, there was all the testimony. We saw it on the big screen. This dramatic, lighten up blue. And that's the drama. And you see it, and it has colors and lights. But the actual testimony is that none of this was black. That's, I'm going to suggest to you, that's smoke and mirrors. I don't know what's showing you these photos where stuff lights up and then it turns out it's actually not evidence. That is not helpful. It's like anti-evidence. That is not something that is useful or helpful, and it definitely is not something that helps them prove anything beyond a reasonable doubt. It's the opposite. But it is concerning when people get on the stand and they talk about their degrees and they talk about how hard they worked and they did these things, and then they act like they found something when they really didn't. It's always weird when to stand up here and beat up on the police, right? Police do good things, they also do bad things. We know it, right? We all know it. Anybody reads the newspaper knows it. They're not perfect, they're not completely imperfect. But the important part, the part that matters to us here, is what they did in this case, what they didn't do in this case. I don't know, maybe it's normal to not do a report for 2 years. Try and do it from memory 2 years later, all this time later, try and get those facts, and then come into court and act like they know what happened. Maybe that's normal. Seems a little bit weird to me. But we know from this witness stand that that's the sort of thing that was happening in this case.
one officer said when he had to fix something in his report, he went and did an addendum and typed it all up and showed right up. That first detective who talked to us said it's impossible. Once it's down there, it just stays there. And that was his explanation for how he made a big mistake. How he said there were 6 shots when there was actually 1 shot. He said, I couldn't possibly go back in and fix it. It's been 7 years. Couldn't possibly do another report that explained something as important as 6 shots, 1 shot. I know that's not 6. I don't have 6 fingers. But what are some of the other things, some of the really big things, some of the very important things that were alluded to but not really explained from this witness stand? They told you, multiple witnesses, most recently Detective Tonelli, but multiple witnesses told you that there were other adults at Hyde Avenue that night. Detective Tonelli said there was the dark-skinned man and the light-skinned man. There was also a Caucasian woman. I think they finally sort of agreed that the Caucasian woman had left before much happened, maybe, but she had been there. They're unable to figure out who this person was. It is confusing to me why, when they have Carter and Taylor, and we're going to talk a lot more about Carter and Taylor, why Carter and Taylor couldn't inform the police who this missing woman was. I would have liked to hear from her. I would like to know. I have investigators who work for me. If the police don't want to interview her, I want to interview her. I want to know what she has to say. Because I don't think that what we heard on the witness stand about Hyde Avenue is honest. I don't think it's correct. I don't think it's credible. I don't think it's true. But we don't get to hear that. But we also heard about the light-skinned man and the dark-skinned man. Now, Detective Tonelli said, well, we just never were able to figure out who the light-skinned man was. I can't invent somebody. Remember? Probably just happened, right? It's Friday. But he didn't say he didn't know who the dark-skinned man was. In fact, he told us who the dark-skinned man was. Why in the world was that man not on this witness stand? There's another eyewitness to all of this. And he knows who he is. And we never heard him. Never heard what he had to say. That doesn't make any sense to me at all. Just gone. The police were picking and choosing. The government was picking and choosing what they showed you in this courtroom. Now, the police had already decided who they wanted to charge. They already had their guy. And no matter what you think about the police, good, bad, or in the middle, when the police think they got their guy, that's what they do. And the problem is, sometimes they're right, but sometimes they're just wrong. But they are tenacious. I don't know Detective Tonelli, and I'm not up here trying to say I do. Never met him before this trial started. He strikes me as someone who had made a decision and decided he was going to charge Brice Rhodes no matter what, and then he did. And then he has stuck to it no matter what. I want to suggest to you that that is not the way our legal system is supposed to work. The good news is that 12
final 12, I know it's 14 of you now, who sit on this case, act as a check to that. Because no matter what the police think for the last 7 years, no matter what they did for the last 7 years, no matter what the prosecution thinks, it's your verdict that counts. You know, when we're talking about things in this case that don't make sense, it's funny, I have kids. After a while, when your kids do or say the same goofball stuff, after a while it seems normal to you. My kids pronounce the words "I love you" "a la boo." That's just how they pronounce it. After a while, it seems normal to me. I type it. It's like a made-up word, just for my family. Right? That's normal to me. That may sound like a strange thing to say, but what I want to explain is that the folks involved in this case have been hearing the same story over and over and over again, and after a while it just starts to, it must make sense. I've heard it for 7 years. The death of Christopher Jones does not make any sense. I hope with your fresh sets of eyes and your ears, you heard that, and the first time you heard it, said, "What? What? This doesn't make any sense at all." It's a fake or made up hit on someone where maybe the wrong person gets, it doesn't make any sense. This is not a plan. What kind of a plan is that? They couldn't make it make sense on the witness stand, and they tried a little bit. And then, when it wouldn't make sense, they just passed the buck. But you know what it does sound like? It sounds like the sort of story, sort of explanation that would get cooked up by two teenagers when they're trying to come up with some version that makes them look a little bit good. Or maybe I should say less bad. Doesn't make any sense. And when I say two teenagers, of course, I'm talking about Taylor and Carter, two cousins, two people who had an opportunity and time to come up with something, both before their arrest and then time after the arrest. I have to talk about this car seat. I don't even know what to say about the car seat. It's so bizarre, it stands out like a sore thumb. But when the prosecutor's trying to say, our police officers, had the highest level of integrity and honesty and professionalism, and you should take for granted all of the testing and all the evidence they collected, I want to suggest to you that the car seat really explains why you should not. We certainly don't have a car seat. We don't have one in this courtroom. You never saw one. I never saw one. But the police, under oath, said, we got a car seat. Said it a couple weeks later. Then a month after that, they were under oath again. And they said, we got the car seat. And they're writing, Detective Tonelli says, write this police report. After that, he's got the car seat. Now, I know he's saying there's a lot of evidence, it's hard work, can't know everything all the time. I hear that.
But there's a few problems with it. One is that when somebody testifies under oath, like in this trial, to you, you have to be able to rely on it. That's why we have people testify under oath. They're supposed to get it right. It is their job to get it right. And if they don't get it right the first time, we certainly expect them to get it right the second time. If they don't get it right the second time, we don't expect them to put it in their police report, which gets sent to all of us, so we can do our job, so we can have the evidence, so we can explain everything as best we can to you. But that's not really the part that's a shocker. The part that's a shocker is 3 years later. You can have all the excuses about overwork and lots to do and everything, and I'm sorry I testified incorrectly under oath, and I'm sorry I testified incorrectly under oath again, and I'm sorry I put it in that report and I didn't fix it. But none of that holds water 3 years later. He said, I didn't realize until the fall of 2016. Okay. This is going to be up to you to decide how much slack you want to cut him. It is. It's not me. It's you. But I'll tell you this. 3 years later, in this courtroom, when he tells a judge, a different judge, but a judge in this case, we've had cases we've gone so long, we have had changing judges. When he tells a judge in the courtroom, when we're having a whole big hearing, like you heard, on all the evidence, what's the biggest piece of evidence? He says, well, I guess it's going to be the big car seat that I bring up here. He told you under oath that he didn't realize what was really going on until the fall of 2016. How can that be correct when he's still saying we got the car seat in 2019? The prosecutor may get up here and say, everybody's overworked and sometimes people are sloppy. Sometimes the police are sloppy. If that's the case, what else was done sloppy? If sloppiness goes to the point of incorrect testimony under oath, how can we judge the credibility of the evidence that you have seen? It raises serious doubts about the credibility. Judge even read an instruction that went to you about tainted evidence in this case. It's not just the defense attorney up here talking to himself talking. Right? That's the law from the judge in this case. But what I want to talk to you about, what I think the most important thing in this police investigation, part that literally woke me up last night thinking about it. It's not the car seat. It's not. They probably thought it'd be the car seat, but it's not. Do you know what I really would like to know, and what I think all of you have a right to know? I want to know about that truck. That burned truck. That stolen truck. I want to know a lot about that truck. Where was that truck stolen? I want to know when it got burned. I want to know where it got burned. And most importantly, I want to know why it got burned. Because I'll tell you, there was an awful lot
of mud thrown at Brice during this trial. But nobody ever tried to say he stole the truck, drove the truck, he burned the truck. You never heard those words from anybody. From anybody. Why in the world did that truck get burned? And why don't I know more about it? Why don't you know more about it? Why didn't we hear more about it? Why didn't the police seem to care about it? So what do we know? What do we know under oath from this witness chair? Well, we know that Carter said he stole it. We know that Carter and Taylor said that he stole it and drove it on the night of Christopher Jones' murder. But we also heard Carter say that he hit Jones with the truck. Now, the ME talked about blunt force injury. I don't know if that's from the truck or not. I have no idea. I know he had blunt force injury to his head. It might be, it might not be. I don't know. Prosecutor may have some opinions about that. They may not. I don't know. But he had an injury to his head. But what I do know is that Carter said he hit him with the truck. He said he hit him while he was down on the ground with the truck. He said he ran him over. The prosecutor asked him, I don't remember the exact question. He asked him something along the lines of, well, you know, by mistake. And he said, no, I hit him with the truck on purpose. That's the prosecutor's witness. That's the believable, credible person the prosecutor has put on this witness stand, is a guy who said he hit poor Mr. Jones while he's on the ground with a truck. For what reason? I don't know. I have no idea. I think the prosecutor didn't know he was going to say that. I certainly didn't know he was going to say that. We know that about the truck. Do you really want to know what I want to know about that truck? I want to know if Maurice Gordon or Larry Ordway's DNA were in that truck. Because you remember from what we heard from the witness stand, their DNA was not in the Mazda. There's so much talk about this Mazda. Their DNA wasn't in the Mazda. But from what I heard, there's this truck being driven by someone who has confessed to being involved that is burned. We don't know why. We don't know when. And that never got tested. I want to suggest to you that maybe that truck is actually what was driving the two bodies of those young men around. Does that sound like idle speculation? I don't know that it is. Because why did he burn that truck? That night, there's all this talk about people trying to burn evidence, right? Was the truck burned the same night? The perfect and logical reason for burning the truck would be, in fact, that it had been used to transport the bodies of those two young men. Think about the story that Taylor and Carter told about how the bodies were removed from the house. Now listen to it again. They're putting totes, those big blue bins. That's what they described. One of them said the sort of thing you put your Christmas ornaments in. If it's big enough to fit a person, it's not going to fit in the trunk of a Mazda. And we don't have a Mazda. I wish we did. Go look at, open the trunk, take out a tote, try and fit it in. But we don't have that. But use your common sense. If all of you have had a car, anything like that, those big totes don't fit. And they're certainly not going to fit two in the back. But you know what they fit in real easy? Back of the pickup truck. No problem. No problem. So you get to decide completely if all the things I just said don't matter. You get to decide. You're completely empowered to do so, right? But I'm going to suggest to you that they're worthy of discussion. They're worthy of discussion because the story you heard from Taylor and from Carter, I don't think is possible. It doesn't make sense. But the part that really bothers me is the lack of investigation and follow-up by the police of the truck. And I want to suggest to you that I believe it's because they had just decided who they wanted to charge. They had decided and they were charging, and that's it. And since he's not associated with this truck, they're not investigating the truck. That's not the way it should work. It's not the way it should work, and it's not the way evidence is supposed to come into this courtroom so that it can be explained to you so that you can do your job. So let's talk for a second about Taylor and Carter specifically. They're cousins. It means they know each other, they're tight. They said they were. They said they were close. How can we evaluate their credibility? Well, one way is, do their stories change? Well, yes, we know they do. The police and prosecutors admit they do. They admitted that they did. There is no question that Carter and Taylor lied. The police are just saying that they like the last version, but that one's not a lie. But there's no question that they lied. There's no question they changed their story. They admitted they did. The police admitted they did. The prosecutor admitted they changed their story. And that's one of the things that we look at and think about when we're trying to figure out if someone is credible, if someone's being honest. Do they change their story? We know that specifically they lied. That's another thing we look at. Not just a changed version, but a full-blown admitted lie. They admitted on the stand that they had lied. They said they were telling the truth on the stand, but they admitted they had lied in the past. Now, Taylor said he was just trying to do the right thing. They were trying to do the right thing. I want to suggest to you that is nonsense. How do we know it's nonsense? We know it's nonsense because when he first came in here, he refused to say a thing. If he is so gung-ho to tell you that's why he's here, he's going to do the right thing and say the right thing, then why did he refuse to say anything while you sat here? You had to leave the courtroom. He's still on the witness stand after you came back. Remember what he said? I got nothing to say. I got nothing to say. I got nothing to say. He had to be threatened in order to answer questions. That is not somebody who's just in here trying to help, just in here to do the right thing. He's doing the opposite. What he admitted when I asked him was he actually didn't ever want to be in a courtroom like this. And he didn't ever want to tell anyone because he didn't think he was going to get caught. It's going to be up to you to judge the credibility of that witness. But I want to suggest that he's not credible. He's not.
that he came in and told you is not credible. And neither was Carter. Now, ironically, maybe you say, well, if Carter wasn't telling the truth, he wouldn't have admitted he hit some guy with a truck. I don't know what he was thinking in this courtroom. Incarcerated, he was the guy who had, came in incarcerated, right, testified. Think about some of the other just cold things that Carter said. Said he hit Mr. Jones on purpose with a truck, no reason. When he was holding a cell phone that he stole from somebody he helped kill, or maybe just killed, he got phone calls. He got phone calls from that young man's mother. And he kept the phone. And he just lied to her. He said, oh, they're sleeping over. He actually said, when asked, I didn't care about her. That may not be an exact quote. That's what he said. He said, I think he might have said, I wasn't worried about her. That's the prosecutor's witness. These are the prosecutor's star witnesses. Confessed, admitted, actual murderers. Their final version is the best of the best. Their final version is, we participated in murders. That's the winner in the contest. They would have said anything the police wanted them to say in order to get out. And they both admitted that their testimony in this courtroom was so they could still have their deal. That's why they're here. But I want to highlight 4 things. Put them up here on this chart. Those 4 things I think are very important. I could have gone back through the versions they gave the police, the 126-page version, which is all nonsense. This is all basically jackknife. And then their later version, and the later version. But to be honest, at some point, I think it just gives everybody a headache. We have a headache already. Here's what I did. I went back through only what they said in this courtroom. Only what they said under oath in this courtroom to you, Carter and Taylor. And I picked out 4 things. Why are they important? Because they both are claiming they're telling you the truth under oath. They say the opposite. So when you're judging their credibility, even if all you judge them from is what they said under oath to you in this courtroom, they're not credible. I'm going to tell you what those 4 things are. The first thing, I'm going to put Carter here. And Judge, if you need me to pivot this so you can see it.
It's okay, thank you.
Carter was the person who testified first. It's N1. Here I'm going to put Taylor. Mr. Taylor testified at the end of the day on Thursday. The first thing that they testified to you about under oath that they disagreed about, we just talked about, but I think it's worthy of the list. Carter said that he hit Mr. Jones with a truck. Taylor said no, he didn't. He got asked. He said, no, that didn't happen. That is Mr. Jones with the truck. And the person who was driving the truck, Mr. Crowe. And we already talked about why I think that's important, because I think the truck's important. But let's talk about a different fact, and one that hopefully jumped out to you folks. The gun that was used, according to the testimony in this courtroom, to shoot Mr. Jones. Mr. Carter was asked, point blank, where was that gun purchased? I can't ask you. I'm going to tell you what he said. What he said is, it was purchased in a trailer park. He said that under oath in this courtroom right there. And what Mr. Taylor said? Taylor said, I purchased it at the home of Larry and Maurice. Same gun, same day. Both prosecution witnesses under oath. There's no wiggle room there. One of those two, I'm going to write it up there. Specifically, he said he purchased it from a relative, Larry Maurice. We don't know all the details of that purchase. But I was surprised when under oath the prosecution's second witness had a completely different version of those. Not some far-off 7-year-ago statement. Folks, we're talking about Tuesday and Thursday. No, Wednesday and Thursday. Those statements are made 24 hours apart. Somebody's lying. Somebody's lying to everybody in this courtroom, and most importantly, that means they're lying to you. Prosecutor may say this next one doesn't matter. I think it does. Remember all the testimony about the vote? I'm going to call it a vote. I'm going to quibble about the vote. There's people talking about whether or not someone is going to be killed according to the testimony. Pretty serious stuff. The kind of thing that you want to get right if you're testifying about the details. Carter said that he was the only one who said no. And he was asked specifically about Taylor. And he said, Taylor voted for death. Now, Taylor didn't even mention it when the prosecutors were asking the questions. He didn't even bring up the conversation. When I asked him about it, he didn't want to call it a vote. Don't call it a vote. I don't care what you want to label it. But he didn't want to talk about it at all. When push came to shove, he testified under oath that he voted for life. He said, no. They can't both be telling the truth. Carter said Taylor voted for death. Taylor self-servingly told you all he voted for life. Why do you think Mr. Taylor didn't want to tell you what really happened? Maybe it's because Maurice threatened him with a knife. Remember what Mr. Taylor told you about that knife? Mr. Taylor said the same knife he got threatened with by the victim was the one he held in his hand when he stabbed the victim. Same knife. Mr. Taylor have something to hide? Yes, he does. He admitted it. He was angry. Of all of the testimony, he's the one with an actual motive to do violence on that night.
And the last, but very significant difference
Is about those Timberland boots. The boots.
What did Carter tell you? Carter said
Taylor stole boots off one of the victims. That's what he said. Taylor stole boots.
I bet you remember what Taylor said.
And I bet you remember because I bugged him about it and asked him about 12 questions about it.
That
He said, I didn't steal any boots, those were mine. Taylor said they were his. He didn't steal anything. Those were his.
You know the problem with that? No matter how much these guys
Put their heads together and came up with a story they did 7 years ago. They did 7 years ago. Their story from 7 years ago is going to have pieces that they never talked about. And also, 7 years is a long time. We'll lose a few pieces here and there. Funny thing about the truth, you don't have to hold on to that quite the same way. You know, if somebody tells me a story and it's true, I'm going to expect that if they tell me that same story 5 years down the road, it's going to be pretty much the same. Now, that I might ask it different. They might tell it a little bit different, but it's not going to have these sorts of whoppers. And you know what else they didn't have the benefit of when they were putting their story together? They didn't have the forensics reports. Because when Mr. Taylor is saying, I didn't steal those, I own those are mine. Detective Vance told you that they belong to the victim, right? I asked Detective Vance, I said, Mr. Carter had an item that belonged to the victim. She had the phone. Detective Vance said, yes. I said, Detective Vance, Mr. Taylor had an item that belonged to the victims. He had these shoes. Detective Vance said, yes. Then I said, and Brice Rhodes didn't have anything that belonged to the victims. Detective Vance said, yeah, that's right. He didn't. But what else do we know about those boots? We know they were tested for DNA. They were tested in multiple spots. We heard the testimony from the DNA folks. And guess what? Mr. Taylor's DNA isn't on his own boots. Oops. It's on his boots. Stole. Just like Detective Vance said. He's in here trying to look good. He's in here trying to protect himself and cover himself. And he doesn't want to tell you the truth. When you're evaluating the credibility of the witnesses that you heard from this witness stand, remember these things. Testimony under oath, spoken to you within 1 day. And it can't be true. They can't both be true. We already talked about Mr. Taylor and the knife. You know why they're in here. They're in here because of these. Now you'll have copies of these. These are yours, right? Everything that got marked as exhibits. It's mostly a lot of photographs, to be honest. And these are gonna go back, and you can have them, you can look at them as much as you want, all right?
But I want to suggest to you that you really do look at them.
Okay? Those two witnesses, the ones who confessed to being part of murders, 3, who we know lied. Nonetheless, this shows what they were looking at was up to life in prison on each murder, on each one, looking up to life. And what did they get? Because they were willing to come in here, they were willing to say what the police wanted them to say in this courtroom. It got reduced from life in prison for each murder to 5 years. 5 years. That's a pretty big drop. That's a pretty big motivation. Just to make sure that they stayed motivated. In this document, it says, even after you serve your time, and you're out, and you're done, you still have to come back to this courtroom, and you still have to testify under oath. And if we don't like it, we want to say that we don't think you told the truth. If we can convince a judge that you didn't tell the truth, then you're back at life in prison. Times 3. So you better do your job and get in here and say what you got to say. It's in black and white. So all of this, we're talking about credibility, all of this matters. Because you're going to have to decide whether or not the prosecutor really proved beyond a reasonable doubt their case. So I want to stop for a second. Why do we even have that? Why does that matter? Why is that the rule? We have that rule because there used to be a time that the police and the prosecutors could literally go out and grab somebody if they didn't like them. Grab them if they just thought that they were guilty. And then they were stopped. There are legal systems where you are presumed guilty and you have to prove you're innocent. That's horrible. And one of them is Iran. I don't ever want to get arrested in Iran. I have nothing against the country per se, but that legal system, I don't want anything to do with it. For a variety of reasons. Imagine how horrible it would be if the police got to say, I think you, I don't want to. Said, I think you did it. This is what we think. And from now on, you're in jail forever. Until you can prove you didn't do it. How horrible is that? We made a choice in this country, and we live by it, and we have excelled because of it. That the government doesn't just get to do whatever they want and charge whoever they want and arrest whoever they want. Because when they do, it may take 7 years, but finally they end up here. And they end up with you. You are here to make sure that it's not a guess. Beyond a reasonable doubt, it's not a maybe. It's not a probably. Doubt. Now, I'm not going to try and tell you what a reasonable doubt is. I'm not going to try and define it. That's up to you to decide. But it's a big deal. It matters. didn't matter, you wouldn't be here. I'm going to ask you to remember all the way back, and I said it once before, that there are two jobs. When you go back into that jury room, your first job is going to be to figure out the best you can what the prosecutor proved beyond a reasonable doubt. Then, and I'm not going to, the judge will read them all. I'm not going to read them at you. I'm not going to, you guys can all read them if you want to. Fine. But to apply the law and the instructions to what you believe the prosecutor proved beyond a reasonable doubt. And I'm not suggesting that's easy. Right? It may take a while. I don't know. It's going to be up to you. It's going to be up to how the foreperson, frankly, runs the show back there a little bit. But I have complete faith that you have. I've watched. You're all paying attention, taking notes. I think that you will do both halves of the job back there. And I appreciate that you're going to do it. I'm going to ask you when you're doing that to remember the credibility of the folks who testified and remember all the other things you know about the investigation. Things can't be, shouldn't be taken at face value. In the final analysis, the prosecution did not meet their burden. I think the police always assume, and government assumes, that if they can put on a big enough show, bring in enough people, that the jurors will just fall in line. Don't do that. You make your own decision, and I'm not going to tell you what it is. But you're more than just pawns for the police. You're the jurors in this case. And what you do matters. In the final analysis, the prosecution did not prove beyond a reasonable doubt the existence of an intentional murder that involves Brice Rhodes. It did not. Now, if you look at those instructions, in there is a definition of wanton. It's a word that probably none of us ever use, but it's a word in our language, and the law likes it. So that's why it's there, and you get a definition of it. Try and make more sense out of it. That one's a little bit more wide open because it covers an awful lot more territory. Just because it's wide open and may seem more like the prosecutor met their burden there, does not mean that they did. You will decide. And there are two different offenses that both require wanton rather than intentional. Again, that's all written down. Judge read it. You can look at it as long as you want. And hopefully it will make sense. There's 12 of you. That's how it doesn't make sense to one person, it makes sense to somebody else. But I'm going to ask you, let me go back into the room and let all the evidence you heard from this stand. Think about the lack of credibility of so much of that evidence. I'm going to ask you to return a verdict of not guilty.
Mr. Griffiths, thank you. Ms. Jones-Brown, would the state like to make a closing argument?
No.
Sorry, I'm gonna have to make It's
squeaky
real
noise.
noisy.
Ladies and gentlemen of the jury, it was Brice Rhodes who decided that Christopher Jones was going to die that night. It was Brice Rhodes who shot him. It was Brice Rhodes who decided that Larry and Maurice had to go. It was Brice Rhodes who stabbed them over and over and over. It was Brice Rhodes who gave the knife to Anwan Carter, to Ja'Cory Taylor, to Tieran Coleman, to the unknown man, to make sure they were all in it. He learned his lesson last time about people talking. It was Brice Rhodes who took those bodies to River Park and burned them. There are so many profoundly tragic parts of this case. I don't know which is the worst. There's Christopher Jones, father of 3, crossing the street in the West End, nothing to do with any of this. Shot dead for the stupidest of reasons. Larry and Maurice, killed because they did what we would want any teen to do in this circumstance. Go to your mom. These 4 children, so desperate for adult male guidance that they keep hanging out with Brice Rhodes even after they became scared of him because of Christopher Jones's murder. There's Ja'Cory, who had nowhere else to go, sleeping in stairwells, going over there even when he didn't want to, because that was a place where he could spend the night. Maurice tied up with a sock in his mouth, bound, knowing his little brother's in the bathroom. There's Larry stuck in the bathroom, not knowing what's going on outside, we hope. And then Larry struggling when he comes out and sees the blood on the floor. Anwan Carter and Ja'Cory Taylor feeling they have no other option but to follow the orders of that man who forced them to participate in the murder of their best friends. Forced them to clean up after, forced them into this life that they now have. Arrest, prosecution, juvenile custody, adult custody, felony convictions, prison, having to come to court and testify. That is what this man has done to this entire group of children. Now, how do you know, based on the evidence presented here, that Brice Rhodes is guilty? A lot of it does have to do with the statements of Anwan Carter and Ja'Cory Taylor, but their statements were corroborated by other evidence in this case. So let's go over what we have. First of all, this case is charged in complicity, and you'll have this definition with you. It's on your jury instructions. But it means that you don't have to worry about who stabbed the fatal stab. If you believe that Brice Rhodes orchestrated this, if you believe that he was in on it, if you believe that he was commanding or soliciting or engaging in conspiracy with them, you don't have to worry about what stab wound killed them. He is guilty of the whole act. To return to how do we know he is guilty, we will start with the murder of Christopher Jones. Now, Anwan Carter told you he was following behind the blue Mazda. He knew that Rhodes was in the driver's seat, or the driver's side rear seat. He saw Rhodes shoot out the window and kill Mr. Jones. He admitted, Mr. Carter did, that he drove over Mr. Jones. And Dr. Lippincott told you that there was a wound on the head, a bruising that could be consistent. We don't know if that head bruising was caused by running over. But whether it was intentional or not, we know that Mr. Jones would not have been in that road lying prone to get run over by the pickup truck if Brice Rhodes hadn't just shot him. So again, complicity, he's in it. Now, Ja'Cory Taylor told you he was right next to Rhodes, inside the Mazda, when Rhodes shot and killed Christopher Jones.
Stop the car. You see somebody in the middle of the street. And Brice told him you understand. Shot him.
Who shot him?
Brice.
Brice Rhodes shot him. Ja'Cory Taylor told you he saw Brice Rhodes shoot him. Now, both of them described the Mazda in front, the pickup truck behind, and you saw on the Ring video that Detective Griffin found on the block that night, from that night, that there is a small car driving past, immediately followed by a pickup truck. And that tells you that they're not making this up. Ja'Cory and Anwan aren't making this up. Again, the shots that night, the one shot followed by 5, you heard that came in on the 911 call. Somebody said one shot followed by 5. Anwan Carter told you that after Brice Rhodes shot Christopher Jones, they drove down the block a little way and he fired off about 5 shots at a house. One shot followed by 5. Now, the defense pressured Detective Griffin on, why didn't you change the report when you only found one casing on the street? This is an example of why you don't change a report. Because it is a fact that the 911 call came in that way. Then later they talked to Anwan Carter. They find out why there are 5 shots following. And this goes to show that they're not making this story up. Anwan Carter was there that night. He wouldn't have known about the one shot followed by 5 that came in on the 911 call unless he was there. Now, this, he was in front. Ja'Cory was in front in the Mazda. I don't know if he turned around, saw what was happening. It makes total sense that he wouldn't have seen. He just saw Brice Rhodes kill a man. Makes total sense that he didn't turn around and see what Anwan Carter did with that car. So we know that they were there. I guess the defense wants you to believe that these kids just, took a Mazda and a pickup truck over there to commit this murder for no reason? That's what doesn't make sense. 15 years old, Larry was 14. So Larry 14, Anwan 15. Then you have Maurice 16, Ja'Cory 17. But these 4 teenagers drove over there. They were there because Brice Rhodes brought them there. And the rest of the story doesn't make sense except how they told it. Larry and Maurice started telling their mother Brice Rhodes was mad about it and he killed them for it. This crime had an effect on these kids, as Ja'Cory told you.
He don't see nobody get shot. I'm not gonna lie, because I was doing this him too. He was also all of us.
You were scared?
So, I said, just be more with it.
The words and emotions of Ja'Cory Taylor, now age 25, having been to prison, having lived 7.5 years since that day. It affected him. It affected Maurice and Larry. And the defense pointed out that when Ja'Cory Taylor first came in here, he wouldn't testify. He started to, then he stopped. It took a while. As they said, he was threatened, but that was with contempt of court, the same thing any witness has to abide by. You come in here, you have to testify when you're under subpoena. He was here for what is possibly the scariest thing that happens to anyone, to come into a courtroom, to talk about what happened, tell about something that's horrific, public speaking, and he had to do it in front of the defendant and in front of the families of the victims. So it is no wonder that he was scared, that he was emotional, that it took him a while to get there. So, they were scared. Larry and Maurice told their mom. Did he tell you what did he do to them?
So we got to kill him.
Brice Rhodes said, we got to kill him. And we'll talk about the instructions later on, but this is how you know it's an intentional murder. He told them they were going to go kill somebody with a price. It ended up being Christopher Jones. And look, we have no reason to think that Christopher Jones had a price on his head, and I'm not saying that the person who did have a price on his head, if that person exists, deserved to die either. No one deserved to die that night. But he told that there was a person with a price on their head, and that's why they were going down there to collect this money. You heard from and Jacory that the money was never distributed, so we don't have any proof whatsoever that Mr. Jones was anything but crossing the street. But that was Brice Rhodes' intent, to kill Christopher Jones, and this is his intent, to kill Larry and Maurice because they were telling. All right, now we come to Saturday, May 21st. Christopher Jensen told you that Rhodes borrowed his car that day, the Dodge Charger. Rhodes admitted in a statement that he probably was in front of Larry and Maurice's house in that car. Later, you have Jacory Taylor and Juan Carter riding around with Q. They stop by Maurice and Larry's. Boys aren't home. They eventually head over to Rhodes's. Q drops them off. Imagine how relieved Q is that he decided not to go in there that night. So Anwan and Jacory arrive. Everything's fine at first. People present are Rhodes, Larry, Maurice, Tyrone Coleman, unknown male, unknown female. I have a few things to say about that while we're here. The unknown female and the unknown male have never been identified because Detective Tonelli has nothing to go on but their complexion and their gender. These were a 15-year-old and 17-year-old witnesses at the time. They went into a house. They weren't introduced enough that they retained names from this situation, if they were introduced at all. Hung out with these people. Female left. The other guy stayed, but they couldn't describe him any more than light-skinned male. So Detective Tonelli can certainly not go rounding up every white female and every light-skinned male in this county, nor do we want him to. He could not continue that investigation without more to go on. But Anwan Carter was able to give him more about Tyrone Coleman. At the time, he was describing him as a dark-skinned male and was able to point out a rap video, local rap video, that fellow had appeared in. So based on that, Detective Tonelli was able to build a photo pack, show Anwan Carter, he identified it, and then the investigation into Tyrone Coleman took off. So with enough information, of course, he continued the investigation. He would have liked to have done it with the other individual, but he did not have that extra clue as to what direction to take the investigation in. Now, Tyrone Coleman is obviously not here. You know that his case is being handled separately. If you believe the rest of this beyond a reasonable doubt, then that's one of those things I talked about in voir dire. Sometimes you do have questions. You're sitting there in the jury room, you might be like, well, I really would like to know why Tyrone Coleman wasn't there. If it's not A or B or C on the jury instructions, if it does not affect your reasonable doubt of those questions, then set it aside. It's a question that you can ask afterwards, but do not let it affect you now. if you believe everything else beyond a reasonable doubt. All right, to return to the events of that evening, we heard from both Anwan Carter and Jacory Taylor. Jacory and Maurice got into it. Maurice grabbed a knife. Jacory jumped back. Brice Rhodes took the knife from Maurice and hit Maurice. He then powwowed with everyone else. What Anwan Carter described as a vote and Jacory described as a conversation. Anwan remembers being the ugly one. Jacory remembers that he and Anwan did not want to do it. I don't know how he was phrasing things. I don't know what Anwan picked up from him. They are both telling about their memories here. And I skipped over this one. Purchase in a trailer park. I don't remember that, but if you do, go with your memory. But obviously, as far as the events of that night with how this gun was purchased, as Jacory Taylor was the one who purchased the gun, we have a great memory of it. Anyway, votes for conversation, discussion. But what is important from that is that Brice Rhodes was still planning to kill them. He still had the intention that they die that night, but he wanted to make sure that everybody was involved. So he tied up Maurice, had Jacory punch him in the stomach as a violation, discipline, I guess. And then he began to stab Maurice over and over.
How many times did Brice Rhodes stab him? Where did he stab him? Was he standing up or was he on his knees?
He was on his knees.
And he stabbed him in the chest?
Chest, stomach. His chest, stomach, on his torso.
He stabbed him in other places? How long did this go on for?
He stopped breathing.
Until he stopped breathing. You saw the autopsy photos. You know that he was stabbed over and over. Larry was in the bathroom. Rhodes dumped Maurice by the door and had them bring Larry out. And he stabbed Larry over and over. And again, you've seen the autopsy photos. We'll have them back there. I don't want to show the courtroom, but we heard the testimony.
Did he know what had happened to his brother? Was there blood in the spot that he was at? Did he respond to that?
Yeah, he tried to kick everything off, get his hands intact, his hands free stuff.
Was his brother making any noise at that point?
Yeah.
So how many times did he get stabbed?
I don't know.
Just stabbing?
He stabbed until he was dead.
Brice did?
He passed the knife on him.
Who did he pass the knife to? Why did he pass you the knife? They're both dead, right?
Yeah. He said, so we all would be in it. So now it's good.
He said we're all going to be in it. He wanted it to be on all of them now. He had learned his lesson on people talking. Jacory's description was similar.
I just looked at you, see me every time I look. Tied him up. Stabbed, not recently.
Who stabbed Maurice?
Brice.
Was Maurice tied up at that point?
Yeah, he was tied up.
What was used to tie him up?
I don't remember his name. He was tied up.
Okay, who did the tying?
Brice. Somebody else that was there on nobody saw he was tied up. He was trying to
What was Maurice doing while this was going on? Who was in the room while this was happening?
Yeah. It was me, brother, Brice, and two other people. Maurice was pretty much fighting, like trying to, he made everyone stab me. Once everyone stabbed me, he kind of moved to the door to have me stared at her.
You were standing by the door?
Two other people that was in there, I didn't really know. They was already there with jackets, so I'm thinking that, you know what I'm saying? My man, I can't do nothing, stand there. Wondering if somebody's gonna do something to us, but I'm trying to interrupt with the thing, so he kind of took my wrist to the door. They all, I don't really know who, but that's when he goes to the door. Larry was in the back. Larry come out the same day after Larry. Once he did Larry, he didn't stab Larry.
Dr. Lippincott told you that the cause of death was multiple stab wounds. She said Larry had 21 stab wounds. You can see in Maurice's autopsy photos that he has 8 to his abdomen alone, other wounds to his back, other areas of his body. Dr. Lippincott told you the areas, abdomen, torso, pelvis, back, groin, genitals. Rhodes made Anwan and Ja'Cory clean the house while he took the bodies over to River Park and set them on fire. He later drove the boys around to various dumpsters burning evidence. The knife was never found. We introduced photos of the knives that were collected to show you that police collected what they could find. We don't know, maybe those are the murder weapon. I don't think so. They don't match the description. They drove around different dumpsters that night, setting different dumpsters on fire. I would assume that's where the murder weapon is. As Detective Peters told you, there were approximately 7 reports of dumpster fires that day. And by the time 2 days later that he was checking, most of them had already been emptied. It's actually amazing that the pink blanket with Maurice's DNA on it was located. Anyway, that night, they noticed the back seat was bloody, so Rhodes tore it out and dumped it behind someone's garage, as Anwan Carter told you. Before I turn the page here, whether Taylor stole the boots, he said that he and Maurice both had those boots, that they started out as his, he lent them to Maurice. He didn't remember how the boots got there that night. He took the boots at the end of the night, though, and they had blood on them. So it's just all part of the investigation. Now, yes, their stories are inconsistent on these points. I think there's an explanation for each one, but I also think this shows you that these stories were not concocted. They didn't sit there and memorize each other's statements. They came in here and told you about something they remember from 7 years ago. And these are all minor points. Sorts of things that would become fuzzy after 7 years. The things they did say, the things they do remember, that Rhodes tied up Maurice, that Rhodes stabbed Maurice, that Rhodes made them participate, that Larry was stuck in the bathroom, that Rhodes tied up Larry. Those are the things they remember because that's what you would remember from all of this. All right, we've heard a lot about the police investigation over the past week, so I'm just going to summarize because I know that you all took in all this information, witness after witness. The response to River Park, the lack of any identifying information on the victims, how the police were trying to figure out who they were. It was not until Olmsted Academy contacted police and they realized that it was Maurice and Larry, that the case moved forward. Detective Tonelli went to Elizabeth Wren's house, spoke to her brother TJ. TJ Wren led Sergeant Vance to Brice Rhodes' address on Hyde Avenue. Vance saw Rhodes go into and out of the apartment and then followed him until they could take him into custody. In the defendant's interview, he admitted knowing the boys. You might have noticed, though, that he chatted with the detectives for quite a while. They were phrasing it as a missing persons conversation. Chatted with them for a while before he said, "Oh yeah, TJ told me they were dead." Which would be a little odd if he weren't involved with this. He admitted he was probably in front of their house in the Charger the last day they were seen.
We got video of the Charger being there on Saturday. In front of that police
And yes, Detective Tonelli said that was on video, and it wasn't on video. But that's a police investigative technique. Police don't walk into an interview room and say, "Excuse me, have you participated in 1 to 3 murders lately?" No? Okay, well, thanks for your time. They have to use techniques to get people talking, and that was one that they were attempting. And he did admit to being there, probably. Okay, meanwhile, while this is going on, detectives are over on Height serving a search warrant. And no, there was no bloody scene when they walked in. Why? Because the boys spent all night cleaning it up at the direction of Brice Rhodes. They collect the knives because they know that this is a stabbing case, possible murder weapon. Meanwhile, you have Sergeant Vance and the marshals pinging Maurice's phone, finding it with Anwan Carter, who was so young and naive that he didn't know that police could track a cell phone. Anwan Carter was interviewed. And he didn't change his story multiple times, he changed it once. In the beginning, he told them that he didn't know what happened. Then his mother and sister arrived. He spoke to them. He asked to speak to the police again. And that is when he changed his story. That is when he told police about his involvement and the involvement of Brice Rhodes in this case. Months later, he repeated it at a proffer at the time of his plea, and in court he repeated it to you. But it's important to note that he was already saying this long before the prosecution of the case and any sort of plea negotiations had started. He admitted his involvement, and he talked about doing anything he did at the direction of Brice Rhodes. He talked about Brice Rhodes wanting to kill Maurice and Larry and killing Maurice and Larry, wanting to kill Christopher Jones and killing Christopher Jones that night that he was picked up, May 24th. Thus, the second search warrant, because now police knew where the murder happened. And you saw the pictures of the carpet being pulled up. This is not something police are going to do willy-nilly at everyone's apartment that's involved in a crime. They needed a second search warrant because now they knew that this was a murder scene. And so now they had enough probable cause to go in and rip carpet up. And yes, the video was dark that you heard from Rebecca Kimmer. They tried to get it on video. It was dark. That's why they turned to the next step, which was just taking the carpet itself and testing that for blood. The police also interviewed the person who had rented the car that Rhodes was driving that day, who happened to be his neighbor, who was able to direct police to the blue Mazda with no backseat, reeking of bleach. Both cars were processed. Other people were interviewed, some of them with no further information. There was a child at Olmsted who was interviewed, Brice Rhodes' mother, cousin Q. The next day, Corey Taylor was arrested and interviewed. Detective Peters and Metzler were finishing up the dumpster search, and later Sergeant Vance collected the boots. So what do we know from all of this? From the second search warrant, we know that the carpet was covered in blood, as was the carpet padding. And we know, because Stephen Barrett, the analyst from the lab, The blood matched Larry at an estimated frequency in the nonillions, which is far higher than the billions of people that are on the earth today. So there's a 1 in nonillion chance that that wasn't Larry's DNA. So they took various cuttings from the carpet. On one of them, Exhibit 24-1, it was Larry plus one other person. On the other one, it was Larry. From the carpet padding, same thing, Larry and one other person. The DNA for the other person was too limited to make a determination. But this makes sense, as Larry was the second person to bleed out on the carpet. What else do we know about from the apartment? Thought that was interesting. I'm not saying that everybody that bought White Castle that weekend was involved in this, but I do think that's interesting. All right, we know that these sheets were off some of the beds, pillowcases off the beds, and we know that a lot of bedding was found in that dumpster, burnt and bloody. What do we know from the dumpster search? We know that Detective Peters, Detective Metzler were faced with a dumpster full of trash. We know that the reason they were looking in dumpsters at all was because the back seat was missing. They wouldn't have gone out just to search for one pink blanket. But fortunately, that's what they found. But we'll get there in a second. So they come to this dumpster, it's full of trash. They call in and say, found it, thinking that some of this was going to be the backseat material. And that's what Detective Tonelli was left with. This search, you heard, took hours. It took well past midnight. He'd been told they found the back seat, and they did not come back to him at the end of this and say, we found a lot of bloody sheets and blankets and towels, but we didn't find the back seat. He just did not get that information. So when he went to testify, he testified in the probable cause hearing that he believed they had found the back seat. He qualified it. He said, further testing, we're awaiting further testing, but we believe we have the back seat, because that's what he believed at that time. And it was not until he started getting all the reports, and really, he's got other cases going on. I mean, we all wish that we were all straight on the back seat from the very first moment. But yes, he's got other cases going on. We were sitting here. The judge said, what's the biggest thing you've got to bring in? He's speaking from memory about reports that he looks at from time to time, but didn't study up on before every court appearance, and he said probably the back seat. If he could find the back seat, he would have brought it to you. He would have tested it, but that back seat was never found. And we know what happened to the back seat, something that police only found out about later at a subsequent interview when Detective Tonelli did say to Anwan, what happened to the back seat? And Anwan told him and tried to show him on his phone, tried to show him where the garage was, but only knew the neighborhood, didn't know the exact location. All right, so we have the dumpster. We have the pink blanket found in the dumpster. As Stephen Barrett told you, from the pink blanket, in two different spots, Maurice's blood was recovered. Now, while we are on the subject of the labs, what else do we know? The tire tracks from the scene were compared to the Mazda's tires. Scott Doyle told you it's really difficult to get a comparison on tires, and in fact, in this case, he was not able to identify or eliminate the Mazda. The shoe prints, he was able to eliminate those shoes from the shoes that Brice Rhodes was arrested in. But we don't know what shoes he was wearing that night. I wouldn't be shocked if they weren't burned in that dumpster or a different dumpster. From the Mazda, swabs were taken from the driver's seat back near the headrest. They were presumptively positive for blood, and Stephen Barrett was able to find a partial DNA profile, mixture of at least two individuals Due to the limited nature, no meaningful comparison could be made. So blood was found in the Mazda. It was not found on the parts near the where the back seat would have been, either because that area was bleached. 2 different detectives told you the car smelled heavily of bleach, and the analyst told you that bleach can degrade a sample, or because the blood was on the back seat that got ripped off. Anwan told you that that seat was covered in blood, and that's why Brice Rhodes decided it had to go. That's where the blood was in the car. And the reason that it is not here in these lab reports for analysts to tell you about it is because Brice Rhodes got rid of it. Now, Brice Rhodes' DNA was not found anywhere but on the gear shift or the steering wheel. That's true. But you know who else's DNA is not anywhere on these lab reports? Anwan Carter and Ja'Cory Taylor. The reason that Rhodes' DNA, Ja'Cory's DNA, Anwan's DNA is not all over the place is because they are not the ones who are bleeding out on all these pieces of evidence. It is Larry and Maurice who are bleeding on the evidence, and it is their DNA who is found. If they want to say that because Rhodes' DNA is not on anything, he wasn't involved in this, the same would hold true for Ja'Cory Taylor and Anwan Carter. Their DNA is not on it either. We know they were involved in it because they told you. So the same logic does not exonerate him from that analysis. The DNA in Rhodes' apartment, the DNA on the blanket in the dumpster, the ripped out back seat, these all corroborate what Anwan Carter and Ja'Cory Taylor told you. Obviously, the defense does not want you to trust them. They asked in opening, why are Taylor and Carter still alive? Well, 1, they weren't the people who told their mother. 2, he had learned his lesson and made them get involved in the second one. And 3, police put an end to this before anything could happen in future. We don't know what would have happened 2 weeks later. Carter told the truth 2 days after the murder, after initially not, but then talking to his mother and sister. Do you think that his mother and sister came in there and said, I've got an idea, why don't you tell them that you're involved? Why don't you tell them that you stabbed them too? That's a great idea. No, they went in there and said, tell the truth. If this were not the truth, he would have said, I was just an eyewitness. I just saw it happen. I didn't do anything. The fact that Carter gave them so much information that led to his own conviction for facilitation to murder corroborates his statement. Ja'Cory, the next day, May 25th, said he didn't know anything about it. I'm sorry, there's the Mazda.
What do you all notice about the car?
Hold on. Why didn't you and Anwan just leave during the night?
So
Why didn't you? Well, he was gone. So 2 days after this whole situation, he's forced to participate in the murder, scared, not leaving. 2 days later, he's in an interview room, alone, no father, no mother, no one to talk to, knowing that the last people who told what had happened had ended up stabbed multiple times. So he told police he didn't know what happened. It was not until later, when he had been in custody, ironically safe from this whole situation, until he had an attorney, until he had time to think about this, that he came forward. I'm going to return to the slide that I had skipped. This is back to the back seat. I just wanted to play this for you in case you missed it. Oops.
What'd you all notice about the car?
The backseat.
And so, how was that handled?
Cut the backseat out.
And who cut the back seat out? What did he do with the back seat after he cut it out?
We put it in the back of somebody's garage.
So that's why we don't have the back seat. Okay, hold on. I'll get to this in 1 second. But first I wanted to say, if you don't like the plea deals I did with these co-defendants, that's fine. I mean, that's my signature right there. You can write on the back of your jury forms, I think they got too much time. I don't think they got enough time. I don't think you should have amended down. Well, I don't know how you feel about this. So you can call me up later, look up my office's number, call my office. But if you believe what they told you, if you believe that he's guilty beyond a reasonable doubt, then your feelings about this plea deal don't affect your verdict. I had to make a decision on what to do with Ja'Cory Taylor and Amon Carter. And one of the things that I knew was important was getting you all the evidence that you heard in this courtroom. And these are the sorts of things, sorts of decisions that we have to make in courtrooms all the time. Because the witnesses to crimes are often also the participants in crimes. So if you are mad at what I did, that is fine, let me know. But that doesn't mean that Brice Rhodes is not guilty of murder. And so let us talk about what you need to find under the instructions. So it's actually very logical. You go through page by page. You start with 1A, and then the language for murder and the language for manslaughter second is the same for each victim. I just picked Maurice here because he's the one in the middle. And what's in parentheses is the things that changed from instruction to instruction. So for Christopher Jones's murder, it says the 4th day of May, 2016, and shooting him with a gun. Obviously for Larry's, instead of Maurice, it says Larry, but the date and the manner are the same. But, so for each count of murder, your analysis is the same. You shall find the defendant guilty if you believe beyond a reasonable doubt that in Jefferson County, the instructions actually say in this county, but it's obviously Jefferson County. You saw the map. On or about the dates in question, that he killed each victim by himself or in complicity with others. And we've gone over all that. By shooting Christopher Jones, by stabbing Maurice and Larry. And that in so doing, he caused the death of each of them intentionally. And there's going to be an or that I'll flip to in just a second, or wantonly. You know it was intentional because he planned it, he premeditated it, he told the witnesses in advance that he was going to do it, and then he did it. But let's go to the or that in so doing he was wantonly engaging in conduct which created a grave risk of death to another and thereby caused the death under circumstances manifesting extreme indifference to human life. So I'm going to flip up to the definition of intentional and wanton. Intentional is what you think it is, when the objective is to cause that result, in this case being death. Wantonly is when someone is aware of and consciously disregards a risk, a substantial and unjustifiable risk, that the result will occur. And the risk must be of such nature and degree that disregarding it constitutes a gross deviation from the standard of conduct, standard of care that a reasonable person. So if you believe that he's driving down the road, shooting his gun, not specifically intending to hit and kill Christopher
I'm
Jones.
sorry, can you all approach for just a moment?
Sorry, to make it clear, I'm giving you an example of how this could be a wanton murder. I'm not saying this is the only way it could be a wanton murder. So for an example, because wantonly means that somebody is aware of, okay, first of all, wantonly is not intentional. So that's what I'm saying. It's like we've moved past you. This is only in the circumstance where you all think it's not intentional. So it would be wanton if you believe he's aware of and consciously disregards a risk. So he's aware that shooting somebody is dangerous. He consciously disregards the risk that shooting out the window he could hit a passerby. And that the risk of him hitting a passerby is of such nature and degree that disregard thereof constitutes a gross deviation from what a reasonable person would do. So if you think a reasonable person would know, I shouldn't shoot out the window because I might hit somebody, and that disregarding that is a gross deviation from reasonable care, and that he understood that risk was there and he consciously disregarded it, that would be an example of a wanton murder. So just to go back to this, if you believe that he intentionally murdered Christopher Jones and or Maurice Gordon and or Larry Ordway, or you believe that he wantonly murdered them, so the same with the stabbings, like that he was engaging in conduct that he didn't intend to cause murder, but it was such conduct that one would know could cause murder, that he knew it could cause murder, and that he did it anyway, and a reasonable person wouldn't continuing to stab somebody. That would be an example of a wanton murder with a knife in this circumstance. So if you believe that he intentionally murdered, let's just say Maurice, that he intentionally murdered Maurice, or some of you believe that he wantonly murdered Maurice, all you have, because you see that this is an or situation, as long as all of you believe.
Mm-hmm.
So as long as you all believe that it was intentional or wanton, then all of you believe it was murder. Obviously beyond a reasonable doubt. So to start at the top, because I know this is really complicated, but I don't want to think that I could have explained it better and I just failed to. So in Jefferson County, on the date in question, by himself or in complicity with others, he killed Maurice Gordon by stabbing him with a knife. And we went over the complicity instruction earlier. that it was intentional or that it was wanton. So as long as you all agree that it was murder, then you can sign the verdict form for murder. Now, there is a sub part down here in your instruction, for example on page 14. So the foreperson would sign either not guilty or guilty. So that part, you have to sign one of these, not guilty or guilty. Then, if you found him guilty of murder, you add in there if you agreed all 12 that it was intentional murder. So your choices on each of the murders is either not guilty, no more signatures, or guilty, and then maybe you all agree it's intentional and you sign there, or you don't all agree it's intentional and you don't sign there. So one of these top two has to have a signature, and then it's up to you as to the bottom whether it is in agreement that it's intentional. I apologize that our state gives, these are the instructions that we have. All right, so those are for each of the counts of murder. Now, if you don't find him guilty of murder, you go on to manslaughter in the second degree. If you do find him guilty of murder, you skip the manslaughter in the second degree. So it's murder, or it's manslaughter, or obviously not guilty, but you wouldn't find him guilty of murder and manslaughter for the same victim. It's one or the other. Now, you only go to manslaughter in the second degree if you have found him not guilty of murder. So if you do, you will see that the main difference is that there's no intentional on there. And that in the second clause, it just says that he was acting wantonly. So that A is he killed Maurice Gordon by himself or in complicity by stabbing him with a knife. And B, that in doing so, he was acting wantonly. So it omits the intentional, and it omits the grave risk of death to another, etc. But you don't get there unless you found him not guilty of murder. And I believe, obviously, that we have proven, for all the reasons I've stated, that this was an intentional murder. Now, there are 3 more charges. We have abuse of a corpse. And as you can see, that instruction defines each of the elements as on the 22nd day of May, 2016, he, alone or in complicity, placed the body of Maurice and the body of Larry in a yard off an alley and attempted to burn it, that he had no legal authority to do so, and that in so doing, he treated each body in a way that would outrage normal family sensibilities. I think that's obvious. The other, well, here is Ja'Cory describing his knowledge of this. And he told you the bodies were burned? Did he tell you where he dumped them? West End somewhere. Then the last one we haven't discussed is tampering with physical evidence. You have to find that on May 22nd, he, acting alone or in complicity, destroyed, mutilated, concealed, removed, or altered items from the North Height address, including a pink blanket or the knife or the back seat. If you believe that any of those items were tampered with, then this would come into play. That he did so because he believed that an official proceeding may be pending. That would be the investigation and prosecution. And that he did so with the intent to impair the availability, so that he burned the bloody clothing so that police couldn't find them and that we couldn't bring them into this courtroom. He ripped out the back seat so that police couldn't test it. We couldn't bring it into this courtroom.
Who's driving the car? Brice driving the car. Where do you go to? We're going to like different dumpsters. Dumpsters on fire.
Why different dumpsters?
Just to spread evidence.
You know, you made ammo to the bullet. You got back, you was exposing the evidence.
What type of evidence?
It could have been clothes, it could have been, you said, your sheets on it, was in your car, or something, it was evidence.
And was it blood on it?
Yes, ma'am.
What did you all do with that stuff?
It was took to a dumpster and they burnt the stuff up.
And that is how you know he is guilty of tampering with physical evidence. I have one last slide to show you.
It wasn't presented, all of us pretty much learned. Just guilty.
Ja'Cory Taylor was 17 when this happened. He's 25 today. Anwan Carter was 15 when it happened. He's 22 today. They've both been to prison. They have both paid a heavy price for not having the courage, confidence to stand up to that man. Nothing compared to the price paid by the victims, obviously, but a price nonetheless. Brice Rhodes preyed on this group of children. He killed an innocent man for no reason. Then he killed 2 children for a horrible reason, because they confided in their mother. There is no other explanation, no other possible motive or defendant to explain why those children were murdered so horrifically. Please bring this 7-year nightmare to an end and find Brice Rhodes guilty of these murders. Thank you.
Ladies and gentlemen, at this time we are going to draw who our random jurors will be. Counsel, would you all mind to come up? Thank you all. All right, I'm going to tell you who the alternate jurors are. I'm sorry, John, would you mind to move that easel? All right, so I have drawn randomly, literally out of a glasses case, our 2 alternate jurors. Those 2 of you, I'm going to ask you to remain seated. The rest of you will go with Deputy Mills back to the deliberation room. And Deputy Mills, I just need to swear you, please. Do you swear that you will keep the jurors together and allow no person to speak to or communicate with them on any subject connected with the trial, and you will not do so yourself?
I will.
All right, thank you. So the 2 jurors who will not be going with Deputy Mills are a juror ending in 8801 and juror ending in 9462. So if you all could just stay here, please. The rest of you will follow Deputy Mills.
Can we take this?
Are we allowed to take this?
You can take,
No, your notepads have to stay here.
so the only thing we can take is this, correct?
Cannot take your notepad with you. I said this. Yeah, sorry. I did say that at the beginning as well. And just remember, you'll have 1 copy that you'll have the 4-person sign. All right, for the two alternates, can you all come up here, and counsel, you can come up as well. The camera will need to go off now. All right.
Yeah, thank you.
All right, so we are going to go ahead and let you all go since I have your contact information. But like I said, there's a slight chance, something could go wrong. We could need one of you to come back. So in the meantime, you remain under oath as a juror in this case, and you remain subject to the admonition, which I'm going to read one more time just to be clear. You must decide this case based solely on the evidence presented within the four walls of the courtroom. You must not use internet search engines, websites, blog, or any other electronic tools to conduct any research, post information, or help you deliberate. During the course of the deliberations, do not communicate online with anyone connected to the trial, including witnesses, lawyers, other jurors, experts. And if you accidentally encounter any information about the case from any source, immediately bring it to the attention of the court. The other thing that I'm going to do is because I think what I'm probably going to do is just call you all when we have a verdict, since I've got your information, and then you'll know. I will call you and say, hey, we have a verdict. You're officially relieved from duty. And then if you want to know what it was, I can share that with you as well. Okay. All right, so you all are free to go, and the next time you hear from me will hopefully be me telling you that we have a verdict and will not need you, okay? All right, thank you.
Thank you.
And you all do not need to go to the jury pool room. You can go straight on out. Thank you. Do we have anybody that might be able to just kind of watch them walk to their car?
What do you need?
I'm wondering if we have somebody that can just kind of observe them walk to their car.
Sure, which ones?
The people who just left.
Okay, I'll have to catch up with them.
Okay, well then let's go. I mean, you all also have walkie-talkies. Maybe you could call down to the first floor or something. All right, Mr. Griffith and come up. I have your all's phone numbers. I do not have your co-counsel's phone numbers. I have Mr. Cunningham's. But typically what I'll do is send a group text to all of the attorneys when there's either a verdict or a question.
Traditionally, what happens with Mr. Rhodes is he stay in the courtroom? Does he go back?
No, we'll let him go back, we'll let him stay up here for a while. Who knows? We might get a verdict pretty soon. But it doesn't really matter to me, honestly.
I don't think he ever really had food. Did you ever really get him?
Okay.
If there's any chance
I mean, the jail's not going to deliver food on demand, Mr. Griffiths. I don't know if you've met our jail. But you all are welcome to get him food.
Great.
Honestly, I shouldn't say that. They probably would.
No, I totally
But I bet Mr. Rhodes would. Yeah, I know. They wouldn't be happy about it, that's for sure. Thank you. I got it. All right. Ty, first 433? 434. I see it now.
Sorry, it's a new
Okay.
number.
It's okay. I got it. I'm just going to go ahead and put you all in here.
Yeah, that's on the road.
But that's one bite of Snickers bar. Doesn't count. Better to work. Better to organize now.
No, I know.
Stuff and then have to worry.
Whatever.
They're on the elevator. Everybody's getting it. Okay. Does anybody want me to poll the jury? Okay. And then, what's the other thing I was going to ask you?
Judge, before they leave, if there are signed forms, we'd like to examine them with the Commonwealth up at the bench.
That's fine. Oh, okay. The only other thing I was going to do was talk to everybody about reactions in the courtroom. So I'm going to bring the jury in a moment. I want to thank all of you for being so respectful throughout this trial. I most certainly hope that that continues. If there is a guilty verdict, we will be back another day. Please do not behave in a way that makes me say you cannot come back another day. That goes for everybody. But like I said, everybody has been really respectful. I appreciate it. And that should continue as the verdict is read. Okay, would you mind to, I told them I would ask somebody to signal them.
I would signal them, Your Honor.
Thanks.
All rise for the jury.
All right, everybody may be seated. Who was the foreperson? Thank you. Has the jury been able to reach a verdict in this case? All right, if you could please hand the form to Deputy Mills. Thank you. All right, the court will now read the verdict. Verdict Form 1A, murder as to Christopher Jones. We, the jury, found the defendant guilty of murder. Having found the defendant guilty of murder, we found that the murder was intentional. Verdict Form 2A, murder as to Maurice Gordon. We, the jury, found the defendant guilty of murder. Having found the defendant guilty of murder, we found that the murder was intentional. Verdict Form 3A, murder as to Larry Ordway. We, the jury, found the defendant guilty of murder. Having found the defendant guilty of murder, we found that the murder was intentional. Verdict Form 4, tampering with physical evidence. We, the jury, found the defendant guilty. Verdict Form 5, abuse of a corpse as to Maurice Gordon. We, the jury, found the defendant guilty. Verdict Form 6, abuse of a corpse as to Larry Ordway. We, the jury, found the defendant guilty. I'm now going to ask each of you by just kind of pointing, beginning with the back row and going down and then the front row. Is this your verdict? Is this your verdict?
Yes, ma'am. Yes. Yes.
Yes, ma'am. Yes.
Counsel, can you all approach? All right, so I just kind of want to give you a sort of an idea of what will happen from here. First of all, thank you for your consideration of these matters. In Kentucky, jurors also handle sentencing. And so what we will do next is called the penalty phase of the trial, but we're certainly not going to do that tonight. We have some witnesses who cannot be here until Wednesday. But we also don't want to slow this down too much. As you can tell, we're on track to finish before Christmas, which is good, before the holidays kick in. So what I'm going to have you do is come back tomorrow at 1 p.m., see if we can knock out some of the evidence that we need to get entered. And then Wednesday, I expect will be the day that we conclude, okay? Now, I don't think you will be here too late Wednesday, but there is a chance you could be here after 5. Tomorrow, you'll probably be done by 3:30 or 4. All right, so be back outside the courtroom at 1 p.m. tomorrow. And in the meantime, the admonition remains in effect. You cannot do any research. You cannot post about this case. You cannot discuss it with anyone, including each other, when you're not in the deliberation room. So tomorrow morning, I will again ask if there's anything anybody needs to report, okay? Tomorrow afternoon at 1, thank you. Tomorrow afternoon at 1 p.m. And I believe we'll have somebody walk you all out as well.
All rise for jury.
All right, if everybody could. Let's see. And then I'm going to have everyone else stay in the courtroom for about 5 minutes. Now, Mr. Rhodes, you can stay here, go back, whatever you want to do. I just want to give there some breathing space between the jurors and everybody else. We'll see you tomorrow. Thank you all.